part of the first jury trial that was here by the Honorable Lawrence Allen, who was reassigned by the Ohio Supreme Court because of Judge Trabet's incompetency. I'd like to tell you a little bit of a history about this judge and what this court represents. In October 24th, 2012, at approximately, I don't know, about 10 o'clock at night, a young man by the name of Kyle Miller was 17 years old, working at BP gas station on, I believe, 306. Everything was being videotaped at the time. He got off of work. He went out to his car. The police appeared out of nowhere. All the narcotics, the main ones, everything was being videotaped at the time. They ransacked one of the juveniles' cars after all of the juveniles said that they were not doing anything and their cars were locked. They held Kyle Miller down, opened up his car, searched his car, found nothing. The police officers perjured themselves. That's the Mentor Police Department. Don't let it confuse with Mentor on the Lake. Mentor Police Department and their narcotics units came before John Trabet's on this case. The case number is right here, by the way, so you can know about it. And there's a videotape there for any other defendants that have been dealing with the corruption in the Mentor Municipal Court or with the Mentor Police or their narcotics squad. And in this case, what ended up happening is the officers got on the stand and perjured themselves and said it was a traffic stop and he was stopped for speeding. And in any event, the case ended up being dismissed because by this time this 17-year-old kid on January 7th, 2013 actually blew these people away with U.S. Supreme Court case law, Wong Sung versus United States and Silver Thorn Labor Company versus United States, that this was an unlawful stop and seizure of a car. They violated his civil rights. They assaulted him. Then Johnny Trabet was also involved in a case called Ohio versus Robert Myers. And in the Myers case, he lived in the Headlands down here. And what happened was he was swearing in his backyard by himself. His next door neighbor was a police officer, had problems down in Beechwood, like controlling his slutty wife. And what ended up happening was when the police officer came home from work, he rewound his security camera, and it was so grainy, he turned it over to Lisa Clammer, the late Ted Clammer's proxy little daughter that's unqualified, but she's a prosecutor here in the Mentor Municipal Court. 99% conviction rate, all guilty pleas based upon public pretenders here, intimidating and working with the prosecutor and Judge Trabet. So without filing a single motion, they have everybody plead guilty. And as I said, there hasn't been a jury trial here in 5 years. Getting back to the Robert Myers case, he ended up being found guilty on December 3rd, 2012 for swearing by himself in his backyard. He said the word fuck, he said the word cocksucker, he said the word shit. Lenny Bruce challenged the word cocksucker a long time ago, and as Robert Myers said during his closing arguments, that if Lenny Bruce was alive, he would call both the judge and the prosecutor a cocksucker, okay? Now, as far as the word fuck, Cohen versus California, 1971, the word fuck is a protected speech. So swearing by yourself and saying, oh, fuck, I guess you're going to get arrested if you're by yourself, okay? In any event, as we move forward, what ended up happening was that a lady by the name of Victor or Erm Ziegler filed litigation, actually a rent escrow, in Mentor Municipal Court over black mold and various repairs and maintenance that needed to be done on the property, affecting the health and safety based upon gutters pumping water for years through the walls, created black mold. And Burton Carroll Management ended up right here on this case, ended up putting like 2 or 3 kills on top of it. Black mold would still go through. Victor signed, circulated petitions and everything, and the next thing you know, they retaliated against her after they unlawfully released the rent escrow with not anything being done. The name of the law firm that was involved in this case was Powers, Friedman, and Lynn. Within 2 weeks, Burton Carroll Management, with assistance of Judge Trabet's here, ended up filing a retaliatory and vindictive eviction complaint against her to silence her about the black mold and for exercising her right, federal constitutional right to association and to circulate petitions. What John Trabet did is he denied the right to a jury trial during the eviction and separated the retaliation claim from the eviction. So what happened was Mrs. Victor was railroaded out, or Mrs. Ziegler was taken out of, kicked out of her apartment. She was silenced and intimidated, and then on October 23rd at 9 o'clock on case number, let's see here, 2014-227, the Honorable Lawrence Allen was appointed by the Ohio Supreme Court to actually conduct Mentor Municipal Court's first jury trial in 5 years because of Judge Johnny Trebet's incompetence, personal biasness, and obvious corruption in trying to cover up members of the Bar Association from Powers, Friedman, and Lynn, specifically Robert Friedman and Michael Lynn. And they are attorneys for Burton Carroll for the old Harbor Run Apartments. It's now called the Reserve on the Point, that they changed the name to cover up black mold exposure. John Trebetz was fully aware of the health and safety reasons that was here, but he had to do something to help his fellow attorneys dealing with the fraud from the unlawful release of the rent escrow. So what ended up happening was the attorneys for the specific law firm filed motions for limine on the day of jury trial to tell Mrs. Ziegler and dictate to the court that she shouldn't be allowed to bring in the health and safety violations. She shouldn't be able to bring in witnesses to testify about how retaliatory this particular law firm is, specifically in the case called Millennium Management LTD versus Patricia Johnson, 2012, Ohio, 1044. So what happened was they ended up, the jury compromised their verdict because they figured since she was evicted without being able to present a defense, then she must owe the money for a water bill that doesn't exist. And so what happens is there's at not Millennium Management, Burton Carroll at the Reserve on the Point, what they ended up having was a $44 water bill. They canceled the water service with everybody at the Reserve on the Point, and then told everybody, you're going to pay $44 a month. The problem was, when we did the jury trial and newly discovered evidence, it turns out that they only pay quarterly. That means every 4 months they pay $56 for water for there. So that means that it's called RICO, Racketeering, Influence, and Corrupt Organizations. And so we have a judge here that's receiving money from these people. He has been dictated to by prosecutors. He's been dictated to by other members of the bar. The next time you vote, remember that if you ever want a jury trial, if you ever want the right to defend yourself, and if you ever come to the Mentor Municipal Court, you're going to be surrounded by police officers, by as I was. And as I was asking questions, there was, 7 old, out-of-shape police officers retired, and they just try to intimidate you. And what happens is, this is exactly what goes on with anybody coming in there with any type of charge, and you don't stand a chance here. And the only way that you're going to stand a chance is if you exercise your right. And I try to make my appearance here every single day and tell everybody, plead not guilty, take it to jury trial, expose Judge Trebetz, and whether you take it to trial or plead guilty, you pay the same court fees and costs. The people are coming, Mentor.
Hello, this is AIB Radio. We're going to talk here tonight a little bit about the foundation of the Quorum Novus and the Quorum Non Juda here. Seems to be some confusion here on these documents. So we're going to sit here, we're going to open up, and we're going to explain a little bit about what these documents are, so you can have a better understanding of what this stuff is, how it's supposed to work. We need to go back in, and you need to understand several different things here on these documents. Number one, it goes back in and exposes the entire fraud of the court system. It goes back in and shows how the courts have been operating under the Foreign Sovereign Immunities Act, and how they've been given this sovereign immunity and have been operating in a foreign state capacity against American citizens in this country. You need to go back and read under the Federal Rules of Civil Procedure, Rule 4J. You also need to go back and read under the Federal Rules of Civil Procedure, Rule 17, of interested party, on who can bring charges against you in that courtroom. These are some of the foundations that you're going to have to go back in and understand. And you're going to have to also understand that we are exposing these judges to a lot of corruption, and we're going back in, exposing the embezzlement that the courts are creating against the people. First off, the judge is not supposed to be the one who is sitting down and setting the jurisdiction in these courts. That jurisdiction falls right back into the plaintiff, the accuser, whether it is the prosecutor, whether it is child services, whether it's IRS, whether it's the bank. No matter what the circumstances is, it is supposed to be set by the person who brought you into that courtroom. The Quorum Novus and the Quorum Non Juda is strictly a defensive tool. It is for challenging the jurisdiction of these courts. It's not designed to go in and be used as if you are the plaintiff. Go in because you don't want to go in and sit down and say, well, I'm the plaintiff here and this court don't have jurisdiction. This is strictly for a defensive moot. It's strictly for the defendant to come in and defend himself within the court system. You're also going to find out that when you start running this, the judge are going to be very intimidated with some of this stuff. They're going to want to go out and you're going to have your paperwork either a possibility of being dismissed by the court, being frivolous, being stricken from the paperwork, being stricken from the record. Judges are going to do everything they can to get around this because with this documentation, the judge only has two options with you. And these two options that he's dealing with, either he has to dismiss this thing in your favor, or he's going to sit here and blatantly break the law. But before he dismisses this thing, he's got to get you off subject, got to get you off point. In the quorum novus and the quorum non juda, there's only two things that you have to do. Two. One is stay on point. No matter what that judge tries to do to get you off, you have to stay on point. And that point is jurisdiction. Like we have discussed in other episodes, jurisdiction is supposed to be set by the accuser because there's so many different types of jurisdictions out here, such as admiralty jurisdiction, which everybody has talked about, maritime jurisdiction, administrative jurisdiction. You have federal jurisdiction, you've got state jurisdiction, you've got county jurisdiction, you've got municipal jurisdiction, you've got religious jurisdiction, you've got criminal jurisdiction, you've got civil jurisdiction, you've got family jurisdiction. The list goes on and on and on and on. With each one of these jurisdictions is also a set of laws that's supposed to go with these jurisdictions, so you know what you're doing when you walk into that courtroom. You can't use a bankruptcy law if you're in here in a traffic case. You can't use corporate law if you're out here on a criminal case. They can't bring in maritime law if you're out here and you're dealing with a divorce. All these different jurisdictions have to be set. All these jurisdictions have to be declared so we know what the rules are when we're walking into these courtrooms. But because they're not setting them, we have discovered that these courts are operating under the Foreign Sovereign Immunities Act. That means the jurisdiction of these courts are operating in a foreign state capacity. Operating in a foreign state capacity means that they have no jurisdiction over the American citizen because we come under the 11th Amendment. We're not subject to a foreign state. This is what these courts have used throughout the years whenever we have brought charges against their office. They've always screamed, 11th Amendment immunity, 11th Amendment immunity. We can't be sued by a foreign state. We never realized that that foreign state that they was talking about was us when we brought charges against them. Well, this also goes in the other way. If we are a foreign state to them, then that makes them a foreign state to us. That means they cannot bring the American people in and sue the American people under law or equity. They can't bring charges against us. As we've talked about the quorum novus, this goes back and explains also the different aspects of this, that under the Foreign Sovereign Immunities Act, if they're bringing us in as a corporation, then as that corporation, then they have to give us immunity under this Foreign Sovereign Immunities Act. Now, what's the foundation for the corporation? Like we have discussed here in previous episodes, the Style Manual, which was a manual that was created by the Bar Association for Congress and for the courts. That Style Manual is their grammar book. This goes in and redefines the grammar that we've been taught in school. It goes in, if they use all caps, that's what makes you a corporation. This is part of the scam that they're running on American people. We've also discovered under the Delaware Code, under Title 8, under corporations, under Chapter 6, under 617, how do you name a corporation? Well, a corporation has to have a last name. We've also discovered the Incorporate Trust Company of the Delaware Trust, Wilmington Trust, and Corporate Trust Company of America out of Delaware. That goes back in on March 10th, 1899, where the Esquires, the Bar Association, has went in before the Delaware legislation and has asked them to sit down and create a law, an act providing a general corporate law, which means they wanted the natural person or the corporation to be a natural person. They want the corporation to have all the same rights, all the same privileges. They want the corporation to be registered within the state in the same manner as a natural person. So this is where we come up with how they nailed us. And we're also trying to get our hands on some information prior to March 10th, 1899, where the United States Supreme Court had went back and ruled several years prior to this that a corporation is a natural person, that a corporation has to have the ability to be able to buy, to sell, to be able to function within a state as a living, breathing human being. So by setting the stage, by allowing a corporation to take the image of a person, this is how the courts are nailing it, American citizens in this country. And this is pretty much going to be probably worldwide if you go back and check, that they're also bringing you in your country as a corporation. Foundation of the Coram Nobis is that if you go back in and read Black's Law Dictionary, the Coram Nobis goes back and explains to the court that, excuse me, there's been an error made. Someone failed to disclose. Somebody withheld information. Now, whether it was done deliberately, whether it was done intentionally, or whether it was done through intimidation and through threat, that this information was withheld. Goes back in and tells the court that someone failed to disclose information in this hearing that could have set you free, that could have changed the course of this trial. This is what the Coram Nobis is. Now, they're going to go back and tell you, some people coming in, well, they repealed this and put it under Rule 4, under Federal Rules of Civil Procedure, Rule 60. The thing is, Coram Nobis still shows up in Black's Law Dictionary today. It still goes back in. It still has the same purpose and the same meaning. An error has been made. Someone failed to disclose. You're giving this court the opportunity to sit down and correct the record. Now, what we've been dealing with and have found out is some of these courts are dismissing immediately. Some of the judges are challenging the people. People, the foundation of the Coram Nobis and the foundation of the Foreign Sovereign Immunities Act goes back in to what we've discussed. Back in 1933, under 49 Statute 3097, under Treaty Series 8881, under the Conventions and Duties of the States on December 26, 1933, Congress went in and relinquished the state statutes and turned everything over into international law. On December 9, 1945, under the International Organization Immunities Act, Congress went in and relinquished every single public office over to the UN, bar none. We found this and backed it up with the International Reorganization Rescind Act, that a judge filed paperwork into the United States Supreme Court declaring what Congress did in 1945 was unconstitutional. It was not valid because Congress never once brought it up before the people, for the people to sit here and agree to this. The Supreme Court on October 5, 2005 declined to hear this case. The International Reorganization Rescind Act was never rescinded. It's still intact today. The judge went back and made all the issues to prove that Congress did relinquish all these public offices over. Under Title 8 of the United States Code 1481, it goes back and explains that whenever you took an oath of office, you had to relinquish your citizenship to this country. Under Title 22 of the United States Code, under Chapter 11, under foreign agents, this is what happens to you whenever you sit here and relinquish. You become a foreign agent. Under Title 22 CFR 92.12 to 92.32, these are the oaths of office. And this thing falls under the foreign relationship. Falls back under international law for the oath of office. These are the foundations of what we're dealing with. This is the foundations that we've never supposed to have found out about and never dealt with. So this is why when we're walking into these courtrooms and we're found this kind of paperwork, it is now intimidating the courts because now we're exposing the fraud. We're now exposing the corruption and the misuse of what they're doing to the people. Now, some of these cases we've had people report where the judges have brought in extra security guards to stand behind the people. From what we have discovered, this is where you sit down and make a very simple statement and put it on the record, on the court. Is it your intentions by bringing in these extra armed guards into this courtroom that you are trying to threaten me and intimidate me, and that you have trying to cause me to have fear for my life? That by me bringing forth the truth into this courtroom to defend myself properly, you're now intimidating me and you're threatening to kill me in this courtroom by having these armed guards that all you have to do is say, shoot this person down?
Night of the fight, you may feel a slight sting. That's pride fucking with you. Fuck pride. Pride only hurts. It never helps. You fight through that shit.
Yeah, you were hard on him. That wasn't fair.
That actually, I would say Joe was actually rather soft considering how much he was rambling.
Damn right. It could have been a hell of a lot harder. And they will be if you catch one in a bad mood and he's read your notes prior and he's big judge on town. He ain't going to put up with his shit. He'll just purposely try to troll you into anger. And if your words are not effective, he's just going to be able to push you through and figure this guy's never going to amount to anything that gets me in trouble. And I'm just going to extend him 5 weeks and use this frustrate him thing, shove him to trial. See how he likes that when we open up. All right, here we are for trial next time. I mean, I was nice. Okay, that was nice.
Yeah,
I mean, at
I have
times
to be
I was a
more
hard ass,
effective.
but overall. I mean, if you want to be defendant, I guess I'll do judge one more time. But then after that, I just kind of want to break it up so everybody gets practice at being a hard-ass judge. The point of being a hard-ass judge is it's freedom. Be a total dick, but say what you have trouble with, like when judges say to you, just to see how the defendant handles it so you get more ideas about maybe how you should handle it. It's just, if you know his job inside out and backwards, you're going to know your own so much better. It's awesome.
I agree. You're a good judge. You're very good. But I don't like getting off the rails with these guys. I'm rusty, too. It's been a couple of years, but I look forward to it, man. Fucking try to arraign me. I want to see what happens here.
Okay, what's your charges? Do you have any realistic, or do you want me to just make one up? What case do you want to make up, or do you want to just start off as if I dragged you in here and you don't even know why? Because you can do that, too.
Yeah, I'm here because I got some letter in the mail says that violence will be used against me if I don't show up here. So what do you need?
Let's call it some old podunk matter that was like 10 years ago you never settled, and we're a broke county, so we decided to mail out letters to people and see if they can pay things that are 10 years old. How about that? Like a speeding ticket or something. Parking ticket. Parking ticket's even better.
Oh, okay, whatever. That was my intro as I walked into court, though. I got a threat in the mail. What do you want? This is how we're role playing.
Oh, you want to start? Okay. So the case number is 1, 2, 3, 4, 5, 6, 7, Mr. Alton. So you walk up there. And Mr. Alton, I see from the notes on this case that you've received a letter for a parking ticket. The outstanding balance is now, after time and interest, $425 of an original amount of $75. Oh, it seems like back in 2007. Wow. All right, let's see. How would you like to proceed? We can either explain and hopefully get a reduction in fine. You can plead guilty and accept the fine, or you can plead no contest and we can take this matter to trial. How would you like to proceed?
Well, I'd like to pursue a guilty plea, but I would like to know if I could ask some questions first to make sure I'm fully informed of the cause and nature of the charges against me. Would that be all right?
No, we're not here to answer your questions. I'm sorry, it's not that kind of court. This is a community court, and we have, 20 people before you and 30 people afterwards, and only 4 more hours until the end of the day. So I just need your plea. No contest, or guilty, or guilty.
Well, I'd like to sign a guilty plea right now if the prosecutor put the evidence on... wait, is this traffic? Oh, can't we do something criminal? If the prosecutor
you can certainly handle this.
There's going to be no prosecutor to ticket, right?
There could be a prosecutor.
All right, okay, so there's a prosecutor. Sorry. All right, so if the prosecutor put the evidence on the table that the code and the Constitution apply to me, I'll plead guilty and pay the fine right now, and it'll all be over with.
If the prosecutor does what, sir? I'm sorry, could you speak a little slower for the recording?
Put the evidence on the table that the code and the Constitution apply to me, and that I was within the state of Florida, and I will sign a guilty plea right now, and I will pay the fine and do whatever you want me to do. Probation, whatever you want. I need the evidence first. I can't just go around paying people who say I got to pay them without demanding some kind of proof. So as long as you have the evidence, we're good to go, and I'll pay you and it's all over. What do you say? Fair enough? What do you say? Come on, Judge. Fair enough? Come on. Just come in here. You want me to
I'm sorry, broke character. I'll get back in. Okay.
Want the money?
What is it exactly that you want the prosecutor to put on the table, as you say?
What's that?
What is it you're asking the prosecutor to put on the table? And please do it in a sentence or less.
That the code and the Constitution apply to me, and I was within the state of Florida, then I'll sign a guilty plea and pay the fine.
Okay, I understand that you want to plead guilty and pay the fine, so you don't need to repeat that part anymore. You're under the impression that excuse me, Mr. Alton, I'm speaking. You had a turn, it's my turn, right? So let me speak. Don't interrupt me when I'm speaking and responding to you. All right, so you are saying that you want the prosecutor to put something on the table about codes and statutes applying to you. Do I understand you correctly?
Exactly.
Okay, and you realize this is for a parking infraction that has 0 points on your record, and the fine is $425 because you've waited so long. You are expecting the prosecutor to have a matter in here? The prosecutor was never involved in this originally because you never showed up for court. So I'm not sure what exactly you're expecting when you say that. Do you know?
Well, I expect the prosecutor to be able to prove every one of his accusations, and he's accusing me of being within his jurisdiction. So as long as he has proof of that, I will pay the fine.
The prosecutor is not accusing you of anything, sir.
He's accusing me of being within his jurisdiction, is he not?
No, he is not.
Well, then how do the codes apply to me if he doesn't think I'm in his jurisdiction?
Because there's a difference between the prosecutor and the state of Texas. The prosecutor is doing his job. He's not invested one way or the other. He's not accusing you of anything. Do you understand the way the system works, sir?
You're calling him the state of Texas, or is he the prosecutor, or is he Jim? Who is he?
The prosecutor is an officer of the court. The plaintiff is the state of Texas. That is a difference, sir. And things like this that I don't have the time to explain to you. How would you like to, have you ever consulted a lawyer on this matter? Or would you like to just set this matter for trial and then consult a lawyer between now and trial? Which would you like to do?
Are you denying my right to be fully informed of the cause and nature and charges?
No, Mr. Alton. I'm not going to ask you a question and then let you just abandon it totally and go off on something else. That is not how progress is made. This is my courtroom. In my courtroom, I make progress.
Well, it seems like you're not answering my question. So how come you get to
I don't have to answer your questions, Mr. Alton. My patience is running short with your mouth.
My patience is running short.
I don't have to answer your question. Mr. Alton, you will be quiet, sir. And right now a bailiff is moving to your immediate right.
Not in traffic court, they ain't. They're fucking pussies. Well, down here they are. I don't know about your area. It all depends on where you are and what kind of judge you got. Anyway, yeah, if the prosecutor's got the evidence that the code applies to me, I'll pay the thing and we'll be gone. So, I mean, what do you want to do? You're going to go to a jury trial? You're going to handle a jury?
This isn't. I don't think we need to go any further because of two reasons. One, you're under the impression that you can interrupt a judge. And that's never going to fly. And you're not changing your mind, apparently. And two, dude, you have more run-on sentences than most anybody I've ever heard. And there's no way in hell a judge is going to let you get away with that. He's just going to interrupt you. You're going to get pissed off for him interrupting you. You're going to interrupt, back and forth, back and forth. He's going to troll you into anger because the weakest link in your chain of words, Mr. Alton, is your temper and your pride and your ego.
No, I'm just asking
right now.
I didn't say anything. I was asking questions. Where's the evidence? And I'll plead guilty. I mean, you're the one that keeps railroading me into this bullshit. You haven't answered my question.
Exactly. You think I'm doing that on purpose? I'm doing that on purpose.
I'm not going to let
you are.
Move on if you never answered the question.
I don't have to. Why are you under the impression that judges ever have to answer any questions of yours? Whoever told you that?
Well, because I went to court and they answered my questions. And, you know,
that doesn't mean they have to. That means he was nice.
Not. I've had judges answer them. I've had judges yell at me. I've been thrown out of court. I've been charged with contempt. I've been jailed with contempt. Fuck them.
I don't doubt you. But I'm not saying that you're doing anything wrong by doing that if that's the way you choose to go for your purposes. I'm not here to judge your purposes. I'm here to keep you out of jail and to have these other people learn about Columbo, right? And the Socratic method, which doesn't involve getting thrown in jail and interrupting judges.
Well, you know, just about anybody who's done this or tried this pretty much went to jail. They're fucking locked up or they paid the fine or they cut a deal. You know, this thing is no foolproof. This isn't a plan to get out of this. I mean, this is just, you're just rolling the dice.
There is a way to get through it unscathed, and the goal is to stay out of jail, and there is a way to win.
What?
Absolutely there is.
Oh my God,
I've seen people do it. I've heard my friends do it. Tempted within a word of going to jail, recognizing it, and skillfully dodging it, denying the judge the ability to do so, despite his very best efforts. That's called discipline, good training, practice, and knowing the craft.
Some town I give in, he proved there's no evidence of jurisdiction, drop it. Dismissed for lack of evidence of jurisdiction. I'd like to see that fucking paperwork.
Okay, go ask Scar. He got one just a couple days ago. That's exactly why it was dismissed. They just changed their fucking mind. He denied it, and then he said, I changed my mind. No reason. And it was for jurist freaking diction, dude.
He wrote it in there, lack of jurisdiction, that's why?
No, he said it was because of the motion.
He got his motion approved? Granted.
I don't know how long you've been out of the game, but things have changed, man.
It's a couple years, but I'm just saying it was granted. The motion was granted to dismiss based on lack of jurisdiction.
He just got a victory. Look in the No State Project chat. And it's because he got a big freaking win. If somebody
actually got it thrown out on basis of the lack of jurisdiction, that would be wonderful. I'm all for that. I just haven't seen it yet.
And I'm trying to show you how it's possible, but you're telling me I'm wrong.
MarkStevens.net. Look under their success stories. They're the recent Texas one of a docket number that is specific that can be verified by entering it into the government website, and it'll verify that the jurisdiction of the prosecution was not verified nor proven beyond a reasonable doubt. Therefore, they have dismissed the charges.
Well, that's awesome. Everybody should be carrying that in their fucking pockets when they go to court.
Yeah, dude, there's a lot of success stories. But even throwing out Supreme Court rulings in favor, these judges still take it upon their liberty to blatantly disregard a Supreme Court ruling when it has been factually identified and stated in front of their faces on the record. They blatantly disidentify
they can do whatever they want. Yeah, steamroll, whatever.
Oh, I've brought Supreme Court shit. They about laughed me out of the court.
Yeah, because you can go into any law library, go look up the books, and find Supreme Court cases that just directly contradict each other. So it's like cherry picking, and they know it. I'm really not honestly trying to win an argument against you or be right or prove you wrong. I'm not trying to do any of that. I just have other people here listening. Maybe things have gotten a little more aggressive or whatnot. I don't discount your previous experience. It's something I don't have. I'm sure there are things that that I need to learn myself. But I'm just telling you, they're not going to put up with this shit of interrupting. And if you want to go to jail, then just keep doing that. But nobody here wants you to go to jail.
No, you got to understand, man. When the judge interrupts me first, then I'll interrupt him right back, man. It's all tit for tat. I'm sorry, but it's just another human being. I don't care what dress he has on, what he thinks he is, or what he thinks his fiction is. I don't give a fuck. It's just another human being in front of me, man. And if you're going to interrupt me, I'm going to interrupt you. And if you want to lock me in a cage because I interrupt you, that just makes you a fucking criminal. I'll go toe-to-toe with any judge, and any prosecutor, and any cop. And I've gone toe-to-toe with many cops, man. And I'm telling you, if you call them on it, they back off. They don't respect anything except another barking dog. I'm telling you, they're fucking assholes. They're going to run right over this other guy, this last guy.
I'm agreeing with you, actually. I mean, I'm agreeing with you, but in a way that says, all right, well, you apparently need to be thrown in jail a few more times, and then you'll be back here going, how the hell do I stay out of jail?
Well, no, I never did.
I can't convince you right now otherwise. You sound set in that way. I'm not even going to try and change your mind. I respect you're a grown man. You can make your decisions. It's all good.
All the judges I've been through, they've all been different. They switch judges on me over and over and over again. I got a new judge.
They do that on purpose so that you can't figure out his ways and use it against him. But they do that on purpose. They rotate judges just to keep you off guard, especially us when we come in on evidence of jurisdiction.
I look at all these other stories, and it's the same judge and the same prosecutor for 3-4 years. You know, how come I have 5, 6, 7 prosecutor judges and they keep switching them because they can't answer the question?
I'm on my 1, 2, 3, 4, fourth judge in a courthouse with only 5 judges in it, and I have tiny misdemeanors.
Yeah, did you keep fucking them up, and then they had to switch a judge on you, or
no? Absolutely not. I just went in there being effective, and they don't like it, and they can't stand it. They keep switching.
But why
they pull me out of line alphabetically and throw me at the end, and then find a reason to an extension, like, oh, you asked for a bathroom break because you've been waiting for 45 minutes. Nope, sorry, we need an extension. Oh, sorry, we had a trial before you, and that's not fair. But oh well, too bad. Fuck you. Come back in 5 weeks. I'm drawn off of a lot of hearings for people, a lot of different places. To get a dismissal letter is a beautiful, beautiful thing worth something that money can't buy and you can't quite explain. Things like that universally have a high price, and the high price for you is going to be your pride and your ego and putting this thing away about, he's just another man, and if he interrupts me, I'm going to interrupt him. That's one way to go about it. And again, I'm not judging it like you're wrong. I'm just saying a Columbo approach makes the judge furious, not you. Through skillful communication, you accept all of his interruptions, and you just use a magnifying glass to point them out. The public can hear it. It's all over the transcript. The judge gets pissed because he knows you're being effective on the transcript and that you've got awesome grounds for appeal. And he doesn't even need to know that we hate appeal and don't want it to go there. He's still afraid of it because the only thing they give a fuck about is that transcript. And once they get a tiny whiff that you are trollable, you're done. And you know what? You might as well be a slave to yourself because you don't even have a choice in the matter. You're just on autopilot. I'm going to interrupt because I have an ego and fuck this guy. No,
the judge, you were playing the judge. You interrupted me, man. You're getting this all fucking bass backwards here. Wait a minute.
On purpose. Welcome to reality.
I've been to 40 fucking times, and I've never been interrupted by a judge. I don't carry myself like that. I go in there and I look them dead in their eyes and I ask the questions that need to be asked and I demand evidence. I'm not rude. I'm not obnoxious. I have no ego. Okay. I just want to get this over with. I'm very nonchalant while I'm in there, okay? But you interrupted me, and no judge has ever interrupted me. I've always been able to finish my sentences because I don't go running on with bullshit.
I would like anybody else in the room.
Are you fucking kidding me, Alton?
Yeah.
You've never been interrupted by a judge?
No.
Every judge I've gone in front of has interrupted every damn question I've asked or clarification I've asked them.
And he's as nice as they come.
And they pretend like they stop talking and like they're done. And as soon as you start talking, it's just like they start continuing a sentence that they never...
No, they ignore me. But I'm saying they never interrupted me. They just ignore me and move on.
Were you ever effective with pursuing the evidence of jurisdiction?
Oh, yeah.
I'm sorry, go ahead.
I ask for that all the time. I ask for evidence of jurisdiction. I ask the fucking jury for evidence of jurisdiction. I fucking held out the guilty plea and said, I'll plead guilty right now if these guys can just prove that the code and the Constitution apply to me and I was within the state of Florida. And we'll get this over with right now. Not that I'm guilty of anything, not that I've done anything morally or ethically wrong, but I'll sign a guilty plea because if these laws do apply to me, I would never fight these people because everyone who fights them loses.
So what happened in that case where you weren't interrupted and you did push forward evidence of jurisdiction? What was the end result?
They just railroaded me right into a jury trial, that's all. They didn't
And what happened at the jury trial?
They just judges and everything.
What was the end result, the decision?
Well, it ended in a mistrial. It's over. It actually had to go to the appeals court. The state attorney took it to the appeals court, and then the appeals court sided with me.
So you've beat them. It just had to go all the way to appeal.
Yeah. It ended in a mistrial. They didn't like my questions.
What caused the mistrial?
They didn't like my questions, and they were losing. It looked horrible for them. A mistrial was the only way to get another bite at the apple. And I had a libertarian woman on the jury, man. She was slobbering all over me. She was on the edge of her seat. She was never going to let them convict me. And the prosecutor saw that and knew that. Oh, everybody knew. I walked out there, my mom, my sister, and everybody like, did you see that blonde? She ain't never going to convict your ass.
It's pretty funny that a lot of people would pick that up. That's pretty funny.
Oh, it was obvious. When I was talking to the jury, I was making, she never...
All right, well, I hope that you prove me wrong. And
I don't want to prove you wrong. I want us all to beat the shit out of you every time we go. I don't want
I was making a joke. Oh. I was just saying I hope the judges, you're right, and that the judges never interrupt you, but I bet my life that you're about to get surprised.
But they never interrupted when the point I'm trying to make is they didn't have to because they just ignored me and moved on.
Keep in mind that when there's a critical difference between being in front of a jury and being in front of a judge. And of course that is that the jury aren't bar members. They're not skilled in manipulation. They don't really supposedly have a dog in the race. Yeah, they're sheep and probably want to conform to the judge. They might have still humanity, compassion, empathy, the ability, they're human fucking beings.
Yeah,
So, and that's such a critical difference because you're going to get treated differently in front of a jury than you are in a regular traffic court deal.
Of course, yeah.
Big time.
You got to remember that
Big
the jury
time.
is also threatened with violence and paid money by the prosecutor, the other side, the option, whatever.
Yeah,
your
but
opposition. Your opposition is paying them and
Right.
threatening them. If I paid them and threatened them, what would they do to me? That's not.
No, I understand what you're saying, but I don't want to just blow past the point.
Sure.
You're coming to the role plays here where we're going in traffic court saying, I'm not going to be interrupted because I wasn't interrupted over here and I've been to the jury trial. And I'm telling you that it's likely that you'll be less interrupted in a jury trial because you're in front of a jury and the court knows that the power is with them. They can't be punished if they say, fuck you, judge, I'm going to do whatever I want. And then because of double jeopardy, they can't just throw out their verdicts and just because they didn't like it and just start over.
Well, agreeing with you, I tell you what, the jury was the only time I was free to talk and was able to actually talk and keep talking.
But the point that I'm trying to hammer on is you can't have the same approach going into the traffic courts, misdemeanor courts, and our role plays here because we're trying to be Socratic method in Colombo because that's what's effective. We get interrupted like a motherfucker in here. There's no jury around to make the judge be nice, okay?
I got a relevant clarification that the judge used, but I couldn't figure out a way to effectively fight back against it, and I was wondering thoughts about it. I went through the script, was asking the judge, the softball questions and all that. I came to the fact of the jurisdiction because the prosecutor had said that she didn't submit any of that. She's not required to. So I told him that, but he said now he's taking judicial notice that they have jurisdiction.
I'm sorry, back up.
Yeah.
You basically glossed over some important things. Okay. So you what's your question on the table at the moment? Right before we took judicial notice, what was the last question that you had asked?
Am I presumed innocent of all elements of the allegations here today?
And instead of answering that, he took judicial notice of some other shit?
No, to answer that, he said, yes, you are presumed innocent of all elements of the allegations here today, except for jurisdiction. Because because the court has taken judicial notice that we have jurisdiction, and then went on to his little rant.
Okay, so he has confessed that you're not presumed innocent of jurisdiction by him because he wants it to be so, correct?
Yes.
Now, just to be clear, as an aside, and for posterity and for future reference, right? Do I have the right to be informed of the evidence that you were shown that let you know that?
So asking him for the evidence that he's asking him for the evidence that he's using to take judicial notice.
Don't change what I asked. Did I cut out?
We're talking about judicial notice.
Yes.
Yes.
Well, same as yours the other day.
Yeah. No. What I use against judicial notice is I found out that there are specific requirements for judicial notice, and this is what they use. It's from a book that they use to always quote, at least here. And there are 3 requirements for taking judicial notice. One is that it has to be something that every reasonable man knows, and you can point out to yourself. You can say, "Oh, I don't know that." They might say you're not reasonable, but you can also say, just before I enter this court, I asked everybody in this hall if they know about facts that prove that I'm a citizen and I have to obey the law, and none of the people in this court that are sitting here behind me know about such evidence. So either we are all non-reasonable people, or you can't claim that every reasonable person knows. So that's for the first requirement. The second requirement for judicial notice is to rely on sources that are not in dispute.
Yep.
Sources that are not in dispute, well, can't be the state. Can't be just another judge.
Mm-hmm.
Because, you don't accept that, and that makes it in dispute.
Yes. And if they keep it secret from you, keeping it secret from you is one way to keep it out of dispute, right?
To bring it back to the clarification, just while I was trying to get it specifically written down, Gary, could you restate the question that I was on the second attempt trying to get right?
And yeah, it's going to the same point as Eon made of, the facts in dispute. I was getting to kind of a bit of what he said, so he did a great, kind of expansion on that. But my question was, do I have a right to be informed of the facts that led you to taking judicial notice of that conclusion. What are they? What are the facts that you're taking notice of? I'm taking judicial notice of this conclusion because the facts are so common knowledge. Okay, what are these facts that you're saying are common knowledge? Do I have the right to know them first? Not what are they? Baby steps. Do I have the right to be informed of these facts that you're referring to lead you to the conclusion that you have jurisdiction? To lead you to this judicial notice issue, right? He's trying to use a wrong mechanism, is the point. He's trying to use a mechanism because we're pre-trial. He knows he can get away with a whole lot of garbage. So he's taking judicial notice of jurisdiction, right? A conclusion. He's saying it's such common knowledge, he already knows, and everybody already knows, so it's not even worth discussing. Okay, do I have the right to know these things that aren't worth discussing? Okay, so, but you get the key points. You know, he's saying, I'm taking judicial notice of this thing that's so common knowledge. Great, that's fine. Here's a conclusion that's based on things that are so common knowledge, I'm taking judicial notice of it. Okay, well, given that, the next question becomes, may I know those things? Would you please, do I have the right to get the list of things that are so common knowledge, or do I not have that right?
Clarify it.
We're trying to get him to say, no, you don't have the right to get, you don't have the right to be told what this common knowledge is I'm referring to. Sorry. We're taking his bullshit and making it even more plain, you know?
Yeah, I took a very ineffective approach, and I asked him, like, a judicial notice would mean that it's common knowledge. Well, can anyone in this courtroom tell me how the jurisdiction was acquired?
Yeah,
you don't address any of the officers of the court. You don't address them.
That's fine. And that's fine. I mean, I get you. I get you. You were trying to, well, okay, let me take a break and I'll get this common knowledge information out in the hall that I don't have. Or you can give it to me right here. You're refusing to give me this common knowledge or tell me about it, but insisting that it's common knowledge. So, and you're blocking me from talking to anybody here aside from yourself. So, you know, there's information that I need that is relevant to right now, that is extremely central to the issue that we're talking about. So, can I phone a friend? I should be able to call pretty much anybody, right? No, he said common knowledge. Not common knowledge among attorneys, common knowledge among people. He said common knowledge.
And that's pretty much what judicial notice is, common knowledge.
Right. I mean, that's one of the claims, right? Common knowledge. It's so common that it doesn't even warrant discussion. But that's the thing. He's proclaiming, he's loudly proclaiming that you know something that you don't. And he's insisting you're lying when you say you don't know it. Common knowledge means you know it as well, by the way. To say something is common knowledge means that you know it and you're just lying to them. You might know it. It might be information you actually have. It's just not being communicated to you about what he's talking about. So that's my message. Do I have a right to know about these things that you're proclaiming are common knowledge? Things that are common knowledge, you don't have them going in, fuck you, you don't get it. That's what he's implying, of course. But to actually state it and to put it on the record is a little bit different than implying it. Confessions, man. All about confessions. If there is no topic upon which it is wrongful to exert jurisdiction, to impose upon somebody, to impose an order upon somebody, then all that jurisdiction. So we've already satisfied that we're still at the substantive issue, is still in question. Now, the evidence, of course, that we're always talking about is drawing reality into it. So the nod that they give to reality is always one that is begrudging at best. Well, like the best example is, you know, that guy that was that went to court to be declared legally alive. He himself is arguing in court and lost his case. He was unable to prove that he should be legally alive when he was actually there arguing about it. So it just goes to show you that ethics and reality and legality are three completely separate topics that are only related by people's desire to make one look like the other. In the sense of jurisdiction, that begrudging nod to reality and to ethics by the legal bucket is one that we're constantly working on, and it's an inspirational one. It's obviously not something that physically is, you know, just a matter of the universe in consequence. That's where a lot of natural law ideas go into the bushes. There's nothing in a legal structuring and a legal thought system that makes it be ethical or makes it be influenced by reality. It is purely wanting the fictional story to look like the real world as much as possible. And so there's no way really to discuss jurisdiction and how reality affects jurisdiction without really kind of contemplating that. Because there's nothing about the territory and your physical location except that they want it to seem plausible and to seem sensible. But they'll abandon it. And they always have. Well, do you get mail in our physical location? That's close enough. That's just like being here. We have territorial jurisdiction. No problem. something that you deal with affects something in our jurisdiction? Oh, close enough. It's as if you're really here. Oh, you have a kiosk in our territory? Our tax laws apply to you because that's kind of like you're here. Similarly for personam jurisdiction. My feeling seems to be that there are two ways to impart personam jurisdiction. One is to have injured someone and then be owed justice. And the other is to have voluntarily, given it as a feeling of a sense of duty to your community or a desire to clear your name. There is a procedural element that is substituted for those, which is the service of a notice, kind of how it goes, right? They serve a notice upon someone. The right of avoidance is completely bypassed and ignored as a concept. It is presumed that the person who got the notice is not innocent and owes some response. As a consequence, that when they fail to inquire and exercise a right of inquiry, they are in effect acceding personam jurisdiction, one way or the other. Either they're guilty, and it's not relevant whether they've given personam jurisdiction, or they are not guilty. They're not fully innocent. They're guilty in the sense of needing to respond to the notice, and they didn't care to, or didn't have any objections, or didn't have anything that needed to be clarified, and they just didn't have a response. And as such, the default is that they're something other than guilty or whatever. It's to be a little tricky, though. Well, I mean, the fundamental assertion is that the prosecutor has jurisdiction, or the prosecutor knows that the court has jurisdiction. Let's put it that way. The three subtopics, or all the subtopics, are, well, let's investigate this area of things to show that there is nothing wrong this court asserting jurisdiction. Let's look on the topic of territory. Let's look on the topic of personam. Let's look on the topic of the subject matter. Let's look on the topic of the in rem, of the items that we're going to alter. That anyone who could own it is represented in the ordeal, in rem jurisdiction. What else is there? There's a few others, but without getting into religious matters, I guess. Some people would claim that there's an ecclesiastic jurisdiction type like AL, where they believe that you actually need to have some kind of a religious fulfillment. I don't think they're particularly convinced by this, but you see some weird actions, let's put it that way. You see some strange things go on when people start bringing up biblical requirements and all that kind of fun stuff.
I would think that would fall flat on its face, given that we have a culture in America where pretty much everyone has got this meme of separation of church and state. So why would anyone acknowledge that?
I agree, but it's weird how it does get acknowledged. If you say that I have a religious requirement that forbids me from whatever, they tend to back off on asserting a certain level of imposition on that.
Okay.
field.
Yeah. No. Now I get it. No, it actually makes sense when you frame it that way. It does make sense because they have the whole separation of church and state, but they also have being terrified of trampling on religious.
The fact that they don't claim religious jurisdiction is actually a part of how they act in respect to jurisdiction, which is weird, but. So even though it officially isn't the category of jurisdiction, they still shy away from forcing a Christian to take an oath, for instance.
Interesting.
Even though they'll say they have personam jurisdiction. If you want an example of that, Al, that I just mentioned a moment ago, has a great audio on them dancing around the topic and trying to slide into affirming instead of oathing when it's just a synonym. And he said, no, that's actually still forbidden by, the covenant or whatever he said, and that's just a sidestep to try to take an oath, and I can't do that. But, they just tried different ways of ordering him in different ways of phrasing it. But when you're on the topic of jurisdiction, it certainly is a legitimate topic, even though it's a weird one. And just like that, I mean, they also wouldn't proclaim to have jurisdiction to force somebody or, get somebody to refrain from a religious, activity or something too. Yeah, that's what would hold true. All right. Well, that's been an interesting kind of conversation.
Yeah, I guess I'm back to the drawing board at this point because now I feel like none of the stuff that I wrote made sense.
I do that. I'm sorry.
For your own good.
Yeah. Okay, Mark says this a lot. Mark, on the show, Mark says these exact words a lot. He says, and he's talking about their claim to, have jurisdiction. And he says, quote, if you're physically wherever, then these laws apply, right? He says that a lot. So what exactly is he getting at there then?
So he's asking them, is it your position that if I'm physically within blah, 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 or whatever it be, that your laws apply to me? Is that your assertion?
Right, and they tend to agree with that.
Well, yeah, so he's trying to get them as part of their case that he can challenge them on, right?
Right.
It's not that that's all he could challenge. It's not just, you only get one challenge and you're done. He is getting them to state a concrete piece of their position, which is an element that must be true in order for the accusation to be true. So he's saying, okay, let's identify one element that you need to prove as true, because if it's false, your accusation must also be false. Whether or not everything else in the universe goes your way, if this element is false, you got nothing. So he says, is your position that if I'm standing within blah, 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 that your laws apply to me? Now, notice that they're sidestepping issues of sovereign immunity and all this kind of stuff, because we know that he'll go ahead, remove all those topics from the table. Because he's saying, yes, I'm saying that if you're within blah, 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 then our lives apply to you. And he's not qualifying it with, well, as long as you're not a diplomatic immune person or whatever it is, right? He's getting them to remove all the caveats. And once they have, he can say, okay, great, you have evidence of that. And what evidence do you have of very little element that you just got done clarifying? To say physically and state in the same sentence remuddies those waters, because within the state still isn't clear about whether you're talking about a body politic or geographic location in the universe or what. We're trying to deliberately to get him to state geographic location leads to political jurisdiction, a question of right and wrong. And so we're getting him to draw to say, this line that begins here ends here, and then you're just leaving him with his burden of proof and saying, okay, excellent, you're asserting that it is true. We've gotten you to assert one of the elements of your case. Prove it. What evidence do you have to believe that's true? And it's not, let me test the evidence at this point. That would be a matter for trial. It is merely inform me of the evidence. So it is stating your case. It's making sure that you can't get into trial and then let the prosecutor just keep coming up with different scenarios about why he thinks he's right. What convinces him he's right should be known at the point of arraignment. It's not, oh, I have a feeling I'm right. Now let's explore the issue when we get into trial. That's what they want to be permitted to do. But that is what the whole failure to state a case is all about. And in respect to jurisdiction, we're doing the same thing. We're getting him to state his case on the point of jurisdiction. Why do you believe it's true that you have jurisdiction? Do you have any evidence? Of course, they don't want to discuss it. There's no way for him to win on this point. He can only lose. It's not one of the great things to prove. It can only go against them to fall flat on proving jurisdiction. Because we know the judges already have that presumption. The jurors already have that presumption. Why would you want to address an issue that they already presume true pretty much universally? You wouldn't want to bring up the topic, and that's why they don't want to discuss the topic.
Well, I'm writing a research paper, but I'm also trying to develop some tools to go with it and maybe use outside of the paper itself. I want to build up sort of a flow chart, something that demonstrates the relationship between territorial personam and subject matter jurisdiction, and maybe even other things, eventually. But I want to start here with the basics.
Okay, so the relationship, you mean the historic relationships? Because, obviously there's no factual relationship. These are all abstract ideas.
The relationship between the claims themselves, the claims only, not anything factual.
Territorial personam and subject matter. Okay.
Yeah, I made a post about this in the forum, and I was asking for some clarification on certain parts of it. I'm trying to make sure that I understand the arguments, that I actually know what they're asserting when they say they have this or that jurisdiction. I think I'm clear on the territorial argument, and that's if you're physically here, then these laws apply, and that's it. That's the whole territorial argument.
Well, no, and the 2U part is the problem I'm having, because you instantly dragged in personam jurisdiction to the territorial definition. Our laws apply to everything that occurs in this area that we have jurisdiction over. There's always that we have jurisdiction over as a qualifier, which is always circular, but that's the nature of the beast, is that there is the presumption of itself. So they're defining what they're excluding. So territorial jurisdiction is probably better thought of as what it isn't. It is a claim to not have jurisdiction over anything outside of the territory, except that they don't generally abide by that either. If you're physically in Phoenix, then our lives apply to you is not what territorial jurisdiction is about, the way I understand it, or have ever understood it. Because it's not a you thing. They can have territorial and in rem jurisdiction, for instance, and not care about you, care only about your car. But there's a whole concept of at arm's length. If you are not at arm's length, or if a thing, or if a subject or something is not at arm's length to this territory, then territorial jurisdiction is satisfied, that part of it. But if you don't have jurisdiction, you also don't have any part of jurisdiction. It's a coincidence of all the needed elements of it to be right. That's a horrible sentence, I understand. It's talking about there is nothing wrongful about dictating on the subject of territory if you're not outside of the territory. But that only answers that subcomponent of jurisdiction as a whole. Then you move on to the next thing. Is there anything wrong with imposing upon the person involved? Okay, if not, then we've satisfied personam jurisdiction. Then we have, is it wrong for us to speak about the subject matter and impose in regard to the subject matter? And if it is not, then we have subject matter jurisdiction. All right, and if we've satisfied all those categories, then we've basically shown that there is nothing wrong with us imposing upon person, subject, place, the coincidence of event. And our orders, as long as they only involve those things, aren't wrongful. There's a taste in my mouth from even saying such sentences because there's so much lie in them. But
when we ask the question, has the prosecutor presented facts or evidence that the laws are applicable to give this court jurisdiction, we're speaking to all three, because we've always talked about, well, I'll take the prosecutor's definition of it.
Well, that's because he has to actually contemplate all of it, or he's leaving out one of his essential elements. If he fails to accuse you of being subject to them, then he's failed to accuse you of being subject to them. If he says they're 50% subject to me, that doesn't really get him anywhere. If he goes with a definition of jurisdiction that withdraws his case, then that's on him. That's why we can defer to his definition, because if he alters his definition and goes so limited that he's no longer stated a case, all the better. For instance, if he says Okay, I mean personam jurisdiction only. Perfect. Thank you very much. So you agree that you have no reason to believe that you have territorial or subject matter or other jurisdictions. The issue of personam jurisdiction is a triviality. The court shouldn't concern itself with because it makes no difference if he has one part of jurisdiction, you know?
Now that you've explained all that, now I have questions because now I'm trying to figure out how is somebody going to actually formulate this argument then? How is somebody going to say, I have, what is the argument for territorial jurisdiction exactly? Like I'm, from anyone's perspective, from a prosecutor's perspective, from, someone talking about it on YouTube or whatever, right? How are they going to say that they have territorial jurisdiction?
In the opinion of the bar, it is a matter of competition with the other divisions of the bar, and that's it, right?
Sure.
So that brings in the diocese kind of argument, where it's like, there isn't a place that I know of in the U.S. where there are two states that claim territorial jurisdiction. It is a mutually exclusive map, right? So that is the only issue that they see in territorial jurisdiction. So it's a matter of on whose ground it is. Now, that satisfies an argument between the courts, but not really an argument with the accused, unless the accused is related to one of the other jurisdictions. Like, let's say a governor, you try to sue a governor of another state, and you're like, he's like, you don't have territorial jurisdiction. I was sitting in my office. Obviously, he's raising territorial jurisdiction issues. But as an accused, where you're just like driving down the street, and that intersection isn't an intersection that, between the bar members, they have an agreement on whose territory that is. You're trying to get yourself into an argument that really doesn't concern us. You're trying to argue with the Catholic Church about what diocese you're in when you're not a Catholic. On this post, I see subject matter jurisdiction. A traffic violation was alleged, therefore this traffic court may hear the case.
Right.
An allegation doesn't create a case. An allegation doesn't make a case. You either have a case or you don't have a case. It really depends on the actual factual situation. He's alleging to have a case, of course. You cannot have a case against an actually innocent person. It can be up as a question as to whether they're guilty or innocent, but if they're actually innocent, you never had a case. Which, you never have jurisdiction against an innocent person who isn't voluntarily giving you some level of jurisdiction. But again, you can't be given subject matter jurisdiction over an innocent person no matter what you feel like doing. So it becomes a little bit of a catch-22 in the sense that it can't be right unless it's already right anyways.
Right.
Wrongful act cannot be made rightful by any mechanism involved in this thing, even if the target begs for it. The prosecution of an innocent person, there is no jurisdiction over innocent people. That's the problem. So you have to presume them guilty or take liberties with the idea, at least. Let's put it that way.
I guess maybe it would help if I clarified something. What I'm actually trying to address is not reality. What I'm trying to address is the fantasy of people in the legal system.
I get you. The problem is you're trying to make sense of a legal construct. I appreciate the topic at hand. Really, I do. This is something I've thought, read, and dealt with a bit. But of course, understanding the voodoo is different than accepting the voodoo. And in trying to discuss the topic of an innocent person who is accused of a crime falsely, who does not wish to be arraigned, this is a topic that lawyers really, really weird about. They don't have the tools to address the topic because there isn't a legal construct for it. And ultimately, that's what we're trying to discuss right now, right? We're trying, because the jurisdiction over a guilty person is a little different than the jurisdiction over an innocent person as a topic.
In a way, I'm really enjoying this. I'm really enjoying this perspective. But at the same time, it's actually not necessarily what I'm trying to discuss. What you're describing would be like pushing against the legal system as it is now.
Again, jurisdiction is the right to impose. I mean, in a rough, from the hip kind of way. It is a rightful. It is to say that it is not wrongful to impose upon someone, and that's what jurisdiction fundamentally means.
Okay.
So there is a way to exclude the word rightful and wrongful from this topic. If you wish to say that procedurally versus substantively, if you're only trying to look at procedural jurisdiction questions, not substantive ones, it's very difficult to unzip that. But if you're trying to say, presuming that the substantive jurisdiction issue is already settled as being there, as having jurisdiction, which is how I'm kind of interpreting what you're trying to tell me, is where presuming there is no substantive jurisdiction question, we're now discussing the procedural jurisdiction questions of territorial, personam, and subject matter jurisdiction. Is that what you're trying? Is that a good summary?
Yes, that is a good summary. So, like, if they're pushing against us, and the substantive issue is pushing back against them, but the procedural issue is going with their flow and like pulling them down instead. You know what I mean? Kind of like Mark's entire thing here. Like everything that he's doing is just taking what they're saying and running with it and pulling them down with their own, words, with their own arguments, their own claims.
You can't say that Mark's thing has anything to do with this because we've given up skepticism as a first step. When I said that in order to address the topic you're trying to address, which is the procedural mechanism about jurisdiction, we have abandoned the substantive question, which is it rightful to claim jurisdiction to begin with? We've already bypassed that question. So Mark's whole question, my whole question, the anti-arraignment position, the skepticism, you're already making me step past it in order to address these procedural questions.
Right, as a matter of practicality, and that's, I guess what I mean is like the way, all of this information that he's using to help people to actually defend themselves in court has to skip past that substantive issue, because then you can't address the substantive issue at all.
I'm sorry, I couldn't disagree more. My life for the last couple of years have revolved around rejecting that very notion. You have managed to summarize the exact opposite of my position over the last several years, which I think is rather in line with Marx and with skepticism and so forth. I'll leave you to judge that. But if we maybe can clarify a little bit, maybe we can kind of figure out where we're parting. Okay, so is it fair, I guess, to summarize Marx's position as a question of, do you have evidence of the truth of your claim of jurisdiction?
I think that's fair.
So it's not a counter-positive position. It is a challenge position. It is a Socratic position. So yeah. I'm not saying the opposite is true. I'm just saying, do you have evidence what you're saying is true, Mr. Prosecutor? We're not asking an issue of, have you satisfied the procedural requirements to move forward in a jurisdictional kind of sense? The jurisdictional procedures, the procedures set up to show, the procedures set up on the topic of jurisdiction. We're talking about the real meat and potatoes. Do you have evidence of the truth of it?
Okay.
Falsity.
I see where I got mixed up, because I was thinking that, providing evidence to prove the truth of the claim was a procedural matter.
Evidence of something. So let's say you have evidence that something's true. That is a substantive thing. Now, there can be procedures that the opposing lawyer might use to try to get you to be unable to admit that evidence, even if it proves your thing. Even if it proves the truth of your side, they will try to get a procedural issue so that you can't discuss the truth. And it happens in court cases a lot. Well, that's been suppressed, so piss on you. You're just you look guilty even though we know you're not, because the evidence shows your innocence has been suppressed by procedural issues.
So if the judge says, do you want to argue your motion? You say, my motion speaks for itself. Yep. Otherwise, anything you say will replace the motion. It's like filing an amended motion orally.
Okay.
And then the judge, of course, is just going to blanket deny every motion 9 times out of 10. After you say, my motion speaks for itself, then you say if the prosecutor has any objection to it, or if the prosecutor has any objections to it, then I'd be happy to go over it point by point, and you can take your time and give me the grounds on which you object or want to deny it or are denying it for.
First off, you want to know about the motion. So the best thing to do is just read it. It's not so much because, again, you're going to have to defend it because, obviously Gabe's right. You're not going to have to and should not even attempt. And anytime the judge says, all right, well, here's your motion now, that is a specific tactic to manipulate you into getting you to say something that he can then twist. You wouldn't believe how far they twist to make it seem like the whole thing's invalid, shoot it down on the record, and then that's their good reason to deny it. But if you just shush and don't say anything and say, I don't have anything to add to the motion, did you read it in its entirety? That's always a good one to come back with. I've heard judges pause for 30 seconds and then say, okay, I'm going to take a recess and come back after I've reviewed your documents. No, you didn't even read it. You're just trying to come up here and have a reason to shoot it down. So we're just talking tactics here. So know your thing. No, you don't have to defend it. And then when Gabe says they're just going to blanket deny, what I've seen consistently, I need to start with this first. And Gabe knows all about this. When you go into court your first time and you've submitted these motions, the judge, if they read them, are going to instantly know this guy is on the dead right path to be on to defy us, the court system, the government as a whole, all of our claims, okay? Yeah. And they instantly are afraid of it. I mean, it threatens their career and paychecks and credibility, social status, families, all of it. Everything I've been doing for the past X amount of years, all of it. And so that quite often gets to anger or their A game in manipulating you. So my point is, just know when you pull the trigger and you submit those things, that's very likely what the judge is going to be prepared for. Okay, he's going to know, you're smart enough not to make any claims. You're just asking questions of them. We're not a constitutionalist or anybody coming in saying, oh, we're this, that, and the other. Oh, you need to obey your oath or all this other shit. So just I say this first to make you aware that if you're going to pull that trigger and send those motions, by God, you had better spend enough time in here to know how to keep your ass out of jail, because you need to be prepared. And I'm not saying it will happen, but there is a real, if not a common chance that you're going to be facing some judge's A game who wants to throw you in jail, make you afraid, force your compliance in the future. Be aware. If you're not going to be able to do that, it sounds like you have 3 weeks, so you should have plenty of time. But if not, just be aware that it's better to make main points that you're thoroughly familiar with and then refuse to follow the judge's path down his checklist and then take an extension or request an extension and get the hell out of there with your freedom, because it's very easy for you to do more damage than good by opening your mouth about things you are not 100% positive of. Just remember, lawyers never do that, right?
Okay.
So it's never a good idea. So that's the first part. Do you have any questions about that before I move on to the second?
They're not going to try to use that against me if I don't try to, like, oh, well, you're not saying anything, so you obviously don't know what you even put in there and stuff like that. Well, they might try to use that just...
If pressed with effective responses and attempts to clarify from you, the judge will try every trick in his book and trying to find out where your weakest link is so that he can constantly press that button.
Okay.
And even if that's trolling your pride to make you angry and frustrated and then flustered and less effective as a speaker in defending yourself. So they'll try everything if that's an answer to your question. Be prepared or be ready to make an exception, but always expect them to try and shame you, make you scared, belittle you, humiliate you, make fun of you, have other lawyers in the crowd snicker at the right time. This is all part of it to apply public pressure on you to cave. All right. So it's either going to work or it's not. It's up to you, not me.
Well, one thing I was thinking is maybe you guys could, certain things that you know about the motion that you think might stumble me up or something like that, maybe just like ask me some questions to see if there's certain things that I should know, that you think I should know that I might not.
Well, you don't have to defend it or talk about it in court at all.
Yeah, I know, but I still think it'd be better if I had a better understanding of it,
Let's spend some time doing that, but first I want to briefly go over something that you're actually going to have to do in court, and that is deal with the fact that the judge is going to try and slam dunk deny all your motions in a row before you can even breathe 3 times.
Okay.
He's going to, I've heard them all. He or she come up with all kinds of reasons why this is denied and this is denied. I don't even know what that is. This isn't even appropriate. Anything at all. It's all BS. So their tactic is to bum rush you with denials and then hope you don't object or do anything about it and move on. So you have the right to seek clarification as to the grounds of each one and why they're being denied, and to get that out in the open for him to explain. He's going to go into 1. So as soon as he goes into 1, the second he transitions to 2 without fully explaining, and no, it will happen, then it's objection, point of clarification. I just want to be clear and clarify exactly the grounds you're denying this first motion on. It could be as simple as that. And so you're telling him, I'm not going to let you just slam dunk all these. You got to get it. Of course he's going to deny them all. I'm not suggesting that you do this until he changes his mind. That's not going to happen. Your goal is to get those words out in the open. So that's getting that out. Now you may objection, point of clarification. No, it's not the time to interrupt. Now you're going to let me deal with all these motions and then you can object. That requires an additional objection. Objection, Judge, I don't want to be lazy or shirk my duty. And if I remain silent, that means that essentially I agree and I don't have any clarifications about why you're dismissing the motion on the grounds that you are. So it's my duty to object, and I insist on having the grounds that you're using explained to me. Something in those words, just for your understanding. So no matter what he says, and now he might get angry. Now it's still sticking at it until he threatens jail. So you do that to each one if he tries to. Normally when judges figure out, oh, well, this guy's effective at countering my crap, they stop trying it and they probe in another direction. You'll do that to each one. The motion to dismiss, motion to eliminate, Brady request. You can counter with something that blatantly shows his bias, his lack of objectivity. And it's just a magnifying glass to embarrass them. So, and then once it's, explored out, whatever he gives you a reason, it's always going to be BS. And he'll flip to the next one and, you just kind of stretch it out as much as you can. Because it's not worth going to all the trouble to submit these motions if you're just going to stand mute, let the guy throw him in the garbage, and then you don't say anything about it, because essentially you just threw him in the garbage too. That's the only thing I had to say about those 2 things: the importance of not going into jail and knowing that you're going to get their A game, and the ability to defend it when they try and shoot it down.
Can you summarize the April hearing again for me to connect the dot between the March 29th and now, the upcoming? I mean, was it productive at all, or was it more the same? And who was the judge? Was it Johnston again? I think it was, right?
Well, this was a different matter. This was an interesting surprise because it had to do with a TriMet.
That's right. Okay.
So I had gotten a little citation for having expired fare.
That's right.
And I got the ticket and decided to go in to the court where it said to go on the ticket. And I thought I was going to be walking into an arraignment. Instead, I walked in on a bank of windows, and I walked up to one of the clerks, and she basically asked me how I wanted to plea, and I said, "Wait a minute, you're not a judge.
Yeah.
Don't I get an arraignment for this?" She tried to talk me out of it, and so finally, I started asking about jurisdiction, and so she got somebody else to help her, and this supervisor or whatever she was, and set up an arraignment hearing if that's what you want. So I said, "Sure, we can do that." And as she was setting it up, I thought, oh, wait a minute, I better ask, who's the judge? And she said it was Johnston. And I said, oh, no, there's no way I'm going to get a fair and meaningful hearing. He yells at me and he threatens me. I can't go to a hearing with him. Go ahead.
Well, I was just going to say, by threatening, it came if it came so close, Robbie, if you would have said the wrong word, you would have gone to jail. That's as close as it gets. I mean, you came as close as you can possibly get to jail without going to jail. That's how close that guy took it. So that's what, when you say threat, it's different than when most people do, because you were right there, like twice. He was ready to toss you. Anyways, so you said you weren't going to be in there, and then what?
She didn't really know what to do, and so she said, well, you could wait until, if you want to come back at 1:30, you can come back then, and it'd be a different judge. I said, okay, I'll do that.
Yeah.
And I figured I'd just go downtown and watch a movie or something. And as I'm walking out of the court, I guess as I go down a hallway, I see his courtroom. I see it says Johnston, and it's his courtroom, and there are people waiting in there, but he's not in there yet. So I decide, well, I'll just walk in there and see how he treats. So I sit down in the very back, get out a piece of notebook paper and pencil, and start taking notes. So as he comes in and starts calling up, I'm writing down, what fine amounts people are having to pay. And at one point, he mistakenly, he called me, and I said, well, I don't think I'm on the docket. And he looked down and he said, oh, that's right, it does say it's canceled. And then so he moved on. The courtroom was almost empty. There was just one other couple. There was like two people who were together who he called up. And as they're walking up, or I think they walked up, and he started to ask them, and then realized they shouldn't really be there or something. He looked at me and said, are you recording? And
what the fuck, again?
Yeah, no, this was April 5th.
Okay.
Yeah, he said, are you recording? Just while I'm sitting there. And so I stand up and I say, are you asking me to testify? Are you...
You smart ass. I love it. I love it.
I started trying to clarify, how he could ask me this if I'm just sitting in the audience. And, and what was it?
He's scared of you, Robbie. Scared of you.
Yeah. I made mention of, you haven't asked anybody else here if they were recording.
You did?
And he said, well, nobody else in here has recorded my hearings. And I said, oh, so you're saying that I have? And he sort of backstepped a little and said something like, well, I think you have. And he, as I kept asking questions, he finally told his assistant to call security. And so pretty soon after he said that, in walked a sheriff, and I thought, oh, well, yeah, there's a sheriff. And then more started to come in, and I think there were like at least 8 or 9 or maybe even more of them. I can't remember the number, but as they walked out, I counted them, and it looked like it was about 9. But they were all standing shoulder to shoulder against the walls, just surrounding me. And I looked around, and I finally told the judge, no, I'm not recording. and then I asked, just to clarify, you wouldn't consider it recording if I'm just writing things on a piece of paper, would you? And he said no. And there was like more that we were talking about, because I told him that he was the reason why I had canceled, because I knew that I wouldn't get a fair and meaningful hearing with him. I'm saying this to him. I know that you're violent, so I know there's no way I'm going to get a fair and meaningful hearing. He started to talk and imply that there was a way to, once he got the answer of no, I'm not recording, he was more at ease, it seemed like. So he eventually told I had to like point out the fact, hey, there's guards here, because he asked me something, or hey, is there any way we can get rid of these guards? and he told them it was okay, and they hesitated for a while, but he had to tell them again that it was okay, and they finally left. But then he said, well, if you want an arraignment, then, I can see if the judge down the hallway would let you go in there and be arraigned. And I said, okay. So he had to get his assistant to go ask her if it would be okay. And it was, I think I told him, one of the problems with him was that he was biased, and he had shown bias at the hearing at East County. And he actually said, I can give you that. But you won't have to deal with me again after going down the hallway to this other judge. And so I left.
How long did that last, this back and forth? How many minutes did this exchange go on?
I think it was, I don't know, time was kind of odd right then, but I think it was probably 5 to 7 minutes.
And were you just standing from the pews, or did you actually go up to the front, or what?
I didn't go up to the front, but I went to the middle of the courtroom. So I went from the back pew to middle of the courtroom so I could talk to him. But I was not standing in the...
Or at a microphone?
No.
Wow, for 5 minutes he stops court and talks to you. He wants nothing to do with you, and he'd prefer to get you in jail, preferably be a tackle and hog tie and all that shit, and searched and all this shit. I mean, that's dangerous. I mean, thank God that you have this demeanor where you're always calm and you ask the right questions, man, because If you were the slightest bit uppity or no, I mean, I think that would be enough. I mean, it's just like, God, what you're describing is an intimidating thing. And like, if I were to go in that under that situation, no doubt I'd be bringing my AAA game. Like, I would be 100% aware of my surroundings and words and all that shit. I wonder if, you know how in the beginning, people putting cameras and cell phones on cops was kind of rare, and the cops weren't used to it, and they're like angry or whatever. And now it seems, especially in big cities, it's just more accepted. They've had the training, they're used to it, they know they could be on camera, and they're not so freaked out. And the point is, I wonder if the same thing will happen with the prosecutors and the judges. It's even more interesting with them, because you could always go out and point a camera at the cops, and they can't be like, oh, we're going to throw you in jail right now if you keep doing that, unlike, obviously, the courtrooms. And so the unique thing that this makes you go, wow, what's this going to do, is even in prosecutors' offices and in court, if they realize that, oh, well, this is going to get out forever, when before they had complete control over that. I'm just going, how is that going to change their industry? Because it's a commercial profit industry. How's it going to change when that happens?
I think that's one of the things about what's so dangerous about what we're doing. You know, there's a lot of powerful people who rely on this.
Yeah, and I kind of wonder if there's somebody, if their silly justification somewhere in the back of their head is, yeah, this system is shaky and it's not a perfect system. Nobody says wheels of justice are a perfect system, as if that justifies complete, blatant, ignoring ethics and logic. I wonder if they're thinking, if I don't do this, or if we don't do this, then society will fall apart, and all the lower classes that are all the people that are, violent or criminals, or this would go out and take stuff, they would be emboldened. I just wonder if they think they're some kind of doing some superhero type work for a society that doesn't even recognize it, or some BS like that.
I think they have the right to control society because they're enlightened and they were lucky enough to be given the information and in a position.
They can be as dumb as shit. I've sat and watched some bench trials here at the courthouse, and not only is the main prosecutor, Winston Albright, who's in on my cases, I've seen him try trials, and I'm just going, are you fucking joking? Like, you just submitted a handwritten, quote-unquote, map of the area this car was stopped in that was so poorly presented and made that even the public defender had to object to it, and the judge had to sustain it. And so then you brought in your other Google map thing and did the same presentation, and that one went through. But that was a waste of like 5 minutes on nothing. And I'm just going, wow, this guy's like the number 2 prosecutor on the island. So it doesn't take much. And then to be a judge, I mean, okay, be a good prosecutor. I read the history of these judges. It's like, oh, he's a prosecutor for this time and this time. Oh, he's a prosecutor for these years to these years. And I know what those jobs are and what they do. We all know. I've looked on YouTube. You can look up lawyer training. Somebody's just taken a film of a law school class. That's all it is, a law school class. And a couple of them I came across of these professors teaching law students about juries. Because when they were teaching them about juries, they pretty much, their attitude was that we have juries. They're just regular old common people. You don't have to have a single brain cell in your head to be a jury. And they usually get drunk with this power because all of a sudden, probably for the first time in their lives, they've actually had some real power. And she goes, power, like she, and just treating them like they were just dumb and manipulatable. And she was reading quotes from the past, like, never in the history of such and such has such power been given to so few, such little, just putting them down and everything as a matter of an open law class. And then I should show this shit as opening statements for any trial I have with a jury in it.
It says, quote, the court, on its own motion, reconsiders defendant's motion to dismiss and grants the defendant's motion to dismiss.
Hey. That right there is why the point doesn't go away even when they deny a motion.
Exactly.
Hey, I think he's on. Are you on, Scar?
Yeah, I'm here. I hear you guys.
Yeah. You got the mic, so spill it. We're waiting.
What do you want to know?
I don't know. Anything you got, man? What do you mean, what do you want to know?
Well, I was under the impression that I was going to court again today to talk more with this judge about jurisdiction and dismissing the case. And when I got there, I wasn't listed on the docket, so I asked the clerk what's going on. And they dug up this order that the judge entered apparently last week, like right after hearing that is what I posted.
So what was the history of this case that you think tipped the scales, or what do you got? Tell us, what'd you learn? What'd you get out of it?
It's just, everything that everyone's saying, that they're nasty and they mess up everything they can to get you to come back and mess up your record and lose documents. And Scarlett was there for one of the trials. She was there and she asked questions to the judge afterwards. So I think that also helped and put some pressure on him.
You wanted no piece of that. You tapped out.
Hey, did they recognize you, Scar, when you came to pick up the recording that I requested?
Yeah, I think so.
Cool. So maybe that helped when they realized that you were getting the recording of me talking to the judge afterwards. Huh?
Perhaps I listened to that recording. I don't know if you've listened to it completely, Scarlett, but there's a spot when you left the room to go talk to me outside. They muttered something on the speaker on the microphone that like they thought you were related to me or something, and the judge said, "I don't know, I don't care," or something like that.
Yeah, James told me about that. I haven't listened to it yet. That's funny. That hadn't even occurred to me that they would, of course, they'd be talking about me while I leave the room, right?
Right.
Oh, James said he said probably, but I don't care. So it was insurance and no registration, right? But they dropped the registration because of all those reasons the judge told me on the interview?
I guess so. That might actually be somewhat true because they dropped those charges when I went to file the motion to dismiss. And I don't know why the clerk said she dropped them, or she said, oh, you're not the owner. It's in someone else's name or something. So they dropped those or something.
Well, what the judge told me, remember on the recording, he said that if you fight it, they have to drop them by their rules. They have to drop those charges if it's not your car. And I said, but wait, I know lots of people that have paid no registration tickets for driving cars that weren't theirs. And he said, oh, that's because the system will accept it if you just pay it. But if you fight it, we have to drop it. I was like, oh, that's good to know. That's a fun way to mess with them, at least in Arizona, right? You just go drive a car that's not registered. The title isn't in your name, and then they automatically have to drop it, according to this judge. We've got his testimony on recording.
Right.
Well, Scar, your hearing where the judge took 3 recesses and then pushed you to behavioral court after failing so hard, that was probably the biggest fail, one of the biggest fails I've ever seen on a judge, if not the biggest. And it's got the most views. I should probably put up there something that's like, oh yeah, in this side case, he just killed him there too.
Nice. Yeah, thanks.
Yeah, that's so cool. I'm so excited. That just keeps me going. That's good.
And the way they did it too, they were just like, we changed our mind.
Right.
Yeah, so that was on, I came down and saw your thing on like the 4th or the 2nd or something. What's happened with that case since?
I filed the notice of appeal that same day when we were waiting in the office there. And then like a couple weeks after that, I got an order in the mail that says the judge vacated his decisions because he didn't allow me to record. And I asked to do that properly. So I posted that in the forum. There's a Rule 122 for that. So he dismissed it on that like technicality because he didn't let me record the trial. And then, so he set a review hearing, and that's what I went to last week. That was Thursday.
The same judge, that Riojas?
Yeah, same judge. And so he tried to, I guess, work out a deal with me. Last week he was saying, he was saying, you're probably going to win on an appeal or something, so I'll just give you a new trial now if you want. And I didn't really want that. I said, I wanted it dismissed. And he said, no, I'm not going to do that. And I said, why not? And he said, usually they only dismiss things if there's factually an issue with the case. I tried to attack
failure
that.
to state a case.
Right, exactly. So I tried to argue with him a little about that, which, he gave me a week. He said, okay, well, think about what I'm offering or whatever. And so I was prepared to talk more about the facts and the jurisdiction and the absence of a case today. And then I found out that he apparently entered an order. It must have been right after I left the courtroom that he dismissed it.
Yeah, I thought about it.
Yeah.
So he didn't want your case to go to appeal then?
No.
He didn't want somebody looking at what he had said and done and how he handled that?
Someone already is, because after the first trial that you weren't there at, I filed a complaint with the Judicial Ethics Board, a state, whatever, agency. So that's like above the city court. So I filed that that was back in February. So someone was talking to him.
Okay, so that's good to know too. So that could be another important piece. You get too many people looking at him and they want out, huh?
Yeah.
He was just so proud of himself. He had just conquered the world and saved us all from people like Scar. What could it possibly matter what he said? Yeah, I was fully expecting him to just kick me out. In fact, I had so glad we got the recording because I sent my phone out with my husband because I thought I was going to get in trouble for recording because I sat there recording in the back and it was kind of obvious. So I got rid of my phone and was expecting to get kicked out in 2 seconds, but I just wanted him to know I was there and I didn't approve of what he was doing. But then when he said he would talk to me, I changed tactics a little bit.
We see, it's so weird, the variety of things we see. 1 week we see a guy who's just like, if you don't right now say A or B, I'm going to throw you in jail for a month. And then, we turn around and somebody's like, you know what, on my own motion, fuck it, go home.
That's exactly.
On like a similar ticket, and it's like, so random.
Well, the one big thing is he gave Scar a time limit, right? He's like, you've got 2 more minutes. I've got another case. And he's like, you're giving me a time limit to defend myself? Yes, I am, in his star chamber. And then he talks to me for 45 minutes. Just that one thing alone has got to look really bad for him.
We haven't talked about that tactic of theirs in a while, the time limiting thing.
No, what do you say? What's your response to that?
My point of clarification, if justice takes longer than 2 minutes, I don't have any? Is that what you mean?
Sure boosted everybody's morale up here.
Good. I'm glad to hear. I'm doing this for all the other people out there too. So I'm glad that I could have some success.
And Mark must be ecstatic.
Yeah.
Yeah, and I love that yours was so you totally chose into this. You don't accidentally put another plate on and drive down the street. I mean, you completely chose this.
Exactly.
And you never got into the merits, so they can't say it's because you mentioned that you did have insurance and you did have a plate, right?
Right.
Or, well, I mean, not that I'm faulting you if you did. Tip
No.
that hat.
Yeah, no, I understand that
You
too.
have no
Threats of
idea you
violence.
have plate or insurance, right?
Well, after getting the third ticket and my car impounded, I decided that was enough force of violence, and I did get a plate.
Fair enough. And so from their perspective, they can go at it and say, well, the spirit of the law was served because he got plate,
Does this judge know that you got plates?
I don't know. I never mentioned it to him, but I mean, it's all a matter of public record also.
I specifically.
I mean, for him to, that it wasn't mentioned is important because, I mean, if he went out of his way to look it up, then I guess someone could still say, well, the judge probably looked it up and felt that justice was served. But you know what? That's a kind of a cop-out-ish kind of thing,
Yeah.
We kind of talked about that about the insurance when I was asking him questions, because he was telling me about, if people just come in and show us that they have insurance, even if they get it after the fact, then we can reduce their fine. And I said, did this guy know that? And he said, I don't know. He never mentioned that he wanted, something like that. Like he said, you never mentioned that you had insurance, so he didn't have to mention that he could tell you that if you did, then he could drop your fine. So
yeah, I tried to avoid the merits as much as possible, but this particular judge, he liked to go back to, well, if you're driving, then the law applies and stuff like that.
So the word driving implies that the laws apply.
Yeah,
so,
according to him.
Is there a word for driving that wouldn't imply that we can use here? I'm not for that whole, I'm traveling crap because it muddies up the waters. When I say driving, I mean driving. When a judge says driving, God knows what the hell they mean. But if he says, well, driving is when you're doing this and the laws apply. Oh, okay. Well, then maybe that word shouldn't be used. So give me a word that doesn't have the law applying so that I can use that to describe what I'm doing. He just redefined the word, and it's like, okay, so you're taking the word driving away from me, but now I'm left without a word that makes sense. You're making me use words in stupid ways, and then I would say, well, when I use the word driving, I specifically mean going around, and it may be in a condition where the laws apply to me, and it may not be in a condition where laws apply to me. If you mean driving when you're driving, fine. You can use your stupid definition for yourself. Sorry. Another rant.
No, that's good. I tried to ask him about that, and he says, well, it means you're operating. And I asked him, well, what do you mean operating? And he said driving. Yeah. So he just went in a circular argument.
God. Like, I'm sorry, are you only willing to interchange, driving and operating are synonyms, but what do they mean? Like, yes. Well, because he didn't want to answer the question, of course, right?
Right.
Because, like you said, it means the laws apply. It means that you're operating under the law to them, oftentimes.
Yeah.
And they don't want to be that honest because then you'd say, I don't know if that's true or not. So we need a new word for what I'm saying. They're the ones playing word games.
I wonder if it would be of any use to ask them, what is that defined in your code someplace?
Well, no, you got to remember, it's the accusation. You're accused of driving without license or whatever. Okay, please clarify what you mean by driving. Well, that means behind the wheel of a car, where the laws apply, yada, yada, yada. Oh, okay, the point about where the laws apply, do you have proof of that, or are you just presuming it? Boom, guess where we're at. We're at our normal question. They keep trying to sneak that assertion in so many different ways and get you to say it. Because if they get you to say, well, I was just driving, blah, blah, blah. Oh, you just confessed to one of the elements. Well, I hate these legally packed words.
Yeah.
Driving, operating, vehicle, license, or residence. They're the worst things ever because people don't know what the hell they mean and they still want to use them every damn word.
Yeah.
What's the difference between an automobile and a vehicle? And why do we keep using their word? What's the difference? If they use the word vehicle, I would ask. It's like, I'm sorry, is that a different thing than an automobile? Or is it just a synonym for automobile? And I bet you they'll say, no, it doesn't mean the same thing. But fuck you about what it means. Let me try to find two things. And I don't know if we've ever talked about the idea of moral suasion versus threats of violence. So it's an important concept in legal dealings. Moral suasion is when someone tries to use moral arguments in order to persuade you, to inspire you to do something. It's not a threat of violence, but it might be pointing out negative connotations. It's not offering you a cookie necessarily, but it is making moral points in order to guide you. Moral persuasion, if you want, but moral suasion. Honeyed words, talking about what's right and wrong in senses of justice and duty and whatever else. This would all be moral suasion. Now, the judge is completely within okay territory to use moral suasion to get you to shoot yourself in the foot if he wants. It's a little bit underhanded, but it's difficult for you to then come back and say, oh man, he persuaded me to do something against my best interests, and now I hate that. And that was wrong. It's not wrong to morally persuade somebody of things. It might show a bias, which is a separate wrongness, but in itself, it's not wrong. Now, the difference where they're wanting to push that line is moral suasion goes up to a point, and as soon as you're alluding to a threat of violence, you're stepping over that line, and there's some gray area there. You know, if someone comes up to you and says, hey, the world will be a better place if you give me $1 million. And if he says, and by the way, your wife and kid will be a lot better off if you do too. we're starting to get into a threat territory, right? So it's about moral suasion and clarifying that moral suasion isn't what's in practice here, that it's threats of violence that are at play here. Coercion can be either one. You can be coerced by moral suasion. God will hate you if you do this, is moral suasion. How do I define that line, though? I mean, I hope I've made clear kind of that transition. So, moral suasion to get a not guilty or guilty plea out of you, quite all right. But implying a baculum, a consequence that isn't just a moral consequence, but rather a punishment consequence without regard to right or wrong. Now, if you say, hey, if you hurt this person, they'll hurt you back, that's not a threat of violence. That's just a rightful retaliation or redress. So threatening somebody with an ethically okay consequence is different. So they play that game a lot on the warrant issue. If you don't come in, hey, it's not violence. I'm just going to write out a warrant for your arrest. And they're looking at it as, well, this is just a normal and ethical consequence to your action. So it's not a threat of violence. It's not a threat of violating the rights that you would have. It is a threat of a rightful consequence. So it's our job to start driving that difference because they're trying to protect themselves under the umbrella of moral suasion when really they're issuing a threat of violence. So let's talk in those terms about what led up to you pleading not guilty. Was it moral suasion or was it gray area? Was it something he was trying to communicate a moral suasion and stay on that side of the pool, but you understood it as a threat of violence, or what?
He called my name. I stepped up to the podium. He asked me to raise my right hand, swore me in. I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. So help me, whatever. Then he said, all right, you've been charged here with, how do you plead? Your Honor, there is something on this. No. I just need a plea. Not guilty. And, all right, I will have this. Do you want a bench trial, jury trial? I guess jury trial. All right, jury docket it is. Here we go. All right, you are free to go. The information will be mailed to you. Bailiff, make sure that his address is correct. Have him verify. Is this your address? That is my address. All right, the information will be mailed to you. Okay, thank you. I guess it was based off solely of ignorance of my options. I didn't know I had any of this.
So let's explore your thinking a little bit. Why were you there?
Because I was given a citation with the date on it that said, if you do not show or you do not handle your ticket by this date, a bench warrant will be issued.
So my point is that a threat is leveraged into a further threat is leveraged into a further threat. So let's be cognizant of the threats because let's be aware of them because we tend to gloss over them as if we showed up at court just out of some sense of moral duty, seeking absolution. We were trying to find Jesus or whatever the hell. You didn't feel the ability to contradict this person, right?
Correct.
Because when he said, no, I need you, blah, 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 you interpreted that as a limitation of your options under the threat of pain to you. Or did you just feel that he had a good argument?
I felt that I had no right at that time to speak and that I will be given the right at a later time following their instruction.
So at the time, you would have misused the word right. But the feeling that you had, would you call it, you felt that it would have been unethical for you to speak? Is that truly what you mean? Or that you wouldn't be, or that it wouldn't be tolerated? You wouldn't be given that privilege? Or that privilege would be withheld and you would be punished for not doing so?
I felt that I had something that I was curious on, that I had objections to, and I tried to speak up, got shut down quickly, and I interpreted that as this is not the time and place for that. You'll have the specific right later.
Ethical-wise or safety-wise or what?
I guess just procedural-wise, the way that it happens in court. I didn't want to violate anything. I didn't want to violate any rules of the court.
Why did you not want to violate what you were guessing at were the rules of court?
Because they already had me there on 2 different citations, and I didn't want to inquire any more damages.
Okay, I think you answered me. Let me make sure. What do you mean by you didn't want to be damaged, I guess, if that's what you meant?
I'm already risking having this amount of money having to be paid without any right to help of my own. So I did my best to speak up and was shot down.
Okay. So what were you worried about happening if you had insisted upon an answer that you wanted?
I've seen bad things happen when you don't follow law.
Don't be coy. I'm trying to get you to stop being coy.
Okay, stop being coy. More penalties, more fines, possible threat of jail, pissing the system off, and they're bringing the full hammer down on me.
Thank you so much. Thank you. Okay.
That's what I was fearful.
I knew that, of course, from the beginning. I was trying to get you to stop being coy about it.
I guess that's the easiest way. Yeah. So yeah, the full hammer from the force saying, "Oh, I spoke up, trying to question. Now you're screwed."
You believe that they had the right, ethically, to bring down the full hammer on you over the issue that you're accused of.
That is my full belief because I don't know.
Full stop. New paragraph. Okay. You've satisfied my earlier question. New line of questioning entirely. Or did you believe at the time that it would have been ethically right for the court to bring down the full hammer of your fears? Everything you feared might happen. Do you believe that they would have been in the right to do so to you and that you actually owed that punishment to them.
I believe whether or not they had the right to actually do it, if I stepped out of line, they would have done it anyway and gotten away with it.
Okay. Is my question troubling? So at the time that that you were fearing this doom, did you believe that you were rightly owed that doom, like ethically, not just legally, but ethically, like as a debt to God or whatever, right?
No.
That they would have been the right ethically to have lowered that boom.
No, ethically, no right. I did nothing wrong. I believe that they ethically they would not have that right. No.
Great. Okay, that's great. So your fear was that ethics were not a factor, justice be damned, right? That they would punish you without regard to right and wrong, correct?
Yes.
Boom,
that is
thank
correct.
you.
Based off of ethic, no, I do not believe that ethically they had the right to go ahead and do that, nor did I deserve it on an ethical level. But the fact that they were going to do it regardless of the fact is...
Without regard to right and wrong and truth and falsity, that they would punish you for questioning them.
Absolutely correct.
You felt, rightly probably so, that without regard to right and wrong, and without regard to truth and lie, truth and falseness, that you would be punished for any action that continued to try to clarify the cause and nature of the proceeding. Is that correct?
Yes.
All right. If that is true, then you can stand upon that, and you can argue against it. So it's not that you felt that you owed a plea of not guilty. And it's also not that you felt that it was in the interest of ethics, and it's not that you felt that it was in the interest of truth, and it's not that you felt that it was in the interest of your own defense. It was merely in the interest of avoiding the threat of a punishment that you feared, rightly, and still do fear, probably.
Oh, yeah, most definitely.
That would be handed to you without regard to justice, truth, due process, or any such thing, correct?
Correct.
So that's the motion I would write right there. That it should be vacated on those grounds, is because it was entered merely to avoid an injury and a threat. It was not entered in pursuit of truth or justice or ethic. It was entered because of the coercion, because of a threat of violence. Does that make sense? Because a plea shouldn't be coerced. If somebody had your family held hostage and you entered a plea, doesn't matter. That plea is void because it's not voluntary. And my point is, your plea, because of that threat of violence, isn't voluntary either. And it's certainly not informed because you literally had a question that you wanted answered. And because of the threat of violence, you abandoned that question to secure your safety. And I sound like I'm preaching a little bit, but I'm trying to get you to face something that you just said to me. You know what I mean? I hope I didn't pull something out of you that wasn't true.
No, everything that I said was true. I was just trying to understand and try to clarify exactly that middle point that we were missing to get to that final point.
I hope I'm not mischaracterizing you, though, because I'm going a notch up. I'm stating more definitively that it wasn't a voluntary plea that was without a threat of violence as the main motivation.
Dude, I was scared shitless standing there. I was like, okay, well, I got a question about this indiscrepancy on the ticket. It's not valid. It's like contradicting itself. It doesn't make sense. I can't find any information, and everyone's asking me to ask my questions today.
No. Just want to plea here.
Well, yeah, I know all of that, but I'm just saying my mindset was that, like that little monologue that I just spewed out. That was my mindset. I'm just trying to find more information, all of this stuff right here, and so yeah. Your characterization was I was scared shitless and for good reason.
Well, not good. I mean, good to talk about.
Well, yes, good to talk about reason, but the reason behind it was not actually good. I mean, it was a good reason to be that fearful.
Yes, you had good justification, and you're right, because we do know people who go to jail for less, right? Than trying to ask that question again. And you personally know, well, you know people from here who have gone to jail for, just trying to stand upon getting an answer to a question like that. The way that this topic comes up in court is through a motion to fix the error that was a result of the misdeed. So you talk about the misdeed, you talk about the error, and you talk about motioning to void the error so that it can't continue affecting things because of the misdeed. Does that make sense?
Only thing that doesn't make sense is what kind of motion would that be identified as? A motion for...
Motion to strike.
Motion to strike, plea on these grounds.
The title is motion to strike. The things you're striking is the plea and everything that happened as a consequence to it.
I believe in Texas it's called a motion to strike plea. In Oregon, I believe it's called a motion to vacate plea, but it's the same thing.
You can be more specific. You can title it Joe's motion. Whatever. It doesn't matter. It's a title. My favorite motion. It's a title. Title isn't communicating anything. It's the sentences in that motion that matter. Titles are not given any weight. It can be titled correctly, incorrectly. They've actually ruled on this a few times, I remember, where a title was mislabeled and they tried to void it because of that. And it was actually, found that the title, being that it's not an English sentence of any sort and doesn't actually communicate anything but assistance, is like the things that are in brackets. In a motion, you have things in brackets that are just meant to help with interpretation, but not meant to guide interpretation at all. So that's what brackets mean, by the way.
It's my live case that I'm dealing with. That's what we're trying to prep.
I understand. I'm just trying to recap your live case. If I recall correctly, It was one where he said, "You go back to jail, or you plead right now. One of either guilty or not guilty, or jail. Those are your three choices,
No,
and
that
no
one,
other questions."
that one was not mine.
Well, why did you plead not guilty then?
Because I wanted to fight the ticket and I didn't know how.
Why didn't you vacate that now then?
What do you mean?
Okay, so you pled not guilty in error, right? And
Yes.
you since then have discovered that there's things that you misunderstood, right?
Yes.
So you're in the process of vacating that plea, right?
I don't know. Is there a specific way?
Should you be in the process of vacating that plea? Is what I guess I'm asking.
I should be in the process of vacating that plea. Now, have I taken the actual steps to going? I don't think I have.
If you don't feel, I mean, yeah, I understand. If you understand that you should do something and don't feel like doing it, I don't judge.
But as far as going to vacate the plea, how do I go specifically to that? I've already submitted my motion to dismiss and my discovery request and Brady request. That's when you came in earlier, but where we were at with the motions hearing, because they said, well, you filed your motions, now you should schedule yourself a hearing. And then the role play just now was based on me going into the pretrial hearing and then them saying that stuff to me. So as far as the means to vacate, or is there a specific motion for that?
I can pretend we're right here, and they'll be more useful anyways. So I'll pretend that hypothetical. No problem.
Okay.
Okay, then go on.
Well, real quickly, you said the means to vacate or the motion to vacate. Is there a specific motion to?
You said you make note that you were unaware that you like through a combination of ignorance, fear of asking questions, and so forth. You just now found out that you have a right to be informed of the cause and nature of the proceedings on the point of the applicability of the code. And with that new knowledge, you've discovered that the plea of not guilty is misleading, and you'd like to vacate it. And I would say, in the fear part, I would mention the fear of violence from the judge and or prosecutor and or system court, whatever.
Well, I just don't know if I'm like, sir, I moved to vacate my plea of not guilty.
Well, I mean, this is in writing, correct?
Is it in writing?
Yeah, I do it in writing beforehand. No time like the present. As soon as you know, you should try to set that thing right. Don't wait. If you're waiting, it means you're letting things get screwed up, or you're intentionally waiting in order for things to get screwed up. Neither one of those is an honest way to do things. We're just talking about the truth. I'm not talking about playing games. I'm not talking about lying. Being clear in your own mind what occurred and why things happened, and then communicating that. Why did you plead not guilty? Would you have pled not guilty if you had been in a fireside chat with a tea in hand and no fucking bailiffs in the country?
No, because
there you go. Thank you. No, because
no. Because I originally had tried to say something, got interrupted, and just that whole dominance of the courtroom broke me at that point where I was like, okay, well, not guilty. Now when do I get the chance to actually speak?
One thing I just want to bounce this off you super quick to see what you think, but man, I just can't get this one thing out of my head. So I have this court-appointed attorney. A couple months ago, he had started hearing that I was doing the evidence of jurisdiction in my traffic case, but not in the 420 case, which is what he was on with me. I wouldn't fill him in on my strategies. I would just be like, oh yeah, well, I'm running the show and I'm pro se according to them and you're standby. So don't worry, just sit tight. If I need you, I'll call you. And that was it. He kind of got wind of it and he made a note to before court started to try and ask me what I was going to do this particular hearing. And I'm like, just straight up told him, well, I'm just not going to tell you. And he's like, well, why not? And I said, well, because I've told you this before. It's nothing personal. I just think I have my best interests and you have your best interests. And that's just not always the same. I just don't think it's in my best interest. So anyway, he goes like, well, I think it is, blah, blah. The point of this is this one moment I just can't get out of my head. I'm in the middle of the hearing, I'm doing my shit, and it's like 3 or 4 minutes in, maybe more, I don't know, 5. And then all of a sudden the moment comes where, here it is, I'm now introducing the meat and potatoes to this case too, when I never had before on purpose, because I'd always been trying to get to the jury. And then when I found out they were never going to allow that, and just refile charges to make a jury impossible and just lower the threat to me, still make it 30 days, which is an insane threat. Once I found that out and I decided, okay, I'm no longer trying to get a jury, now I'm just going to go with Mark Stevens. So the moment came, boom, out comes the meat and potatoes. Does the prosecutor submitted evidence of jurisdiction, yes or no? And my lawyer pops up. He almost leaped up and was the next person to talk, didn't even let anyone else finish, and said, I request to be removed from this case on his own when we had never before even rolled that around. Once he heard I challenged the evidence of jurisdiction, whether the prosecutor hasn't submitted it or not, he jumped up as standby counsel. And I'm just sitting here going, what the fuck? Like, what is it that these lawyers, do they just know as soon as anybody goes here? It's like they know the hustle route, and as soon as anybody's lucky enough to get on it, they just have to show that they had nothing to do with it. I did not influence this, and I want off of it. I want nothing. You know what I mean? Like, I'm still a good church-going member. I had nothing to do with this blasphemy. You know? Why would he do that? That is uncharacteristic, and the only reason is he knows the hustle, and he's saving his career, and that's spooky as shit, and I just can't get it out of my head. Maybe I'm overthinking it, but
Sounds like a pretty good explanation. He's clearly afraid to be involved in any fashion.
even his standby.
Evidence that the prosecutor hasn't submitted any evidence of jurisdiction. And you have evidence that the prosecutor hasn't submitted any evidence of jurisdiction at that point because he hasn't.
But at that point, do we know that he has then?
I don't know, Ginger, have you asked that question? Have you already asked the prosecutor if he has evidence of jurisdiction, or asked the judge if the prosecutor submitted evidence of jurisdiction? In real life, have you asked that question?
No.
So you need to have did they address your motions at all?
I don't know. Okay, so I've already went to court. Before I found out about any of this, I had already gone to court, entered the not guilty plea. I tried to get somewhere in the courtroom, but I got quickly shut down because I didn't know what the hell I was doing. How they responded to my motions, I submitted a video that shows just the interaction between me and the clerk as far as anything that happened yesterday. So I'm still waiting for the certified documents from the court stating my next date. Go and do whatever the hell they assume I'm doing.
Okay, so one of the things that I've and a lot of people have failed to do is to set the motion for hearing. Every court, at some time during the week or the month, will have a day set aside, or 2 or 3 or whatever, set aside for motions hearings.
Did you set it for a motions hearing on motion day?
No.
Okay. Yeah, see, nobody knows about this shit, you know?
Yeah.
I'm wondering if
Schedule it.
Yeah, if you can go look at the court schedule and find out when motion day, or call the clerk and ask her when motions day is.
Just call her back and be like, look, I'm scheduled for May 10th for a pretrial hearing. I need a motions hearing before then.
Yeah, just ask her when the next available motions hearing is. And then...
Your trial date doesn't have anything to do with it.
Well, no, I'm not knowing a trial date. They're just saying that my...
Pretrial.
Yeah, that's the next date that they allegedly have given me pending the judge's signature to go back to them.
I'm just saying your pretrial date or whatever date you have has nothing to do with the motions hearing, so you don't even have to bring that up. Just I submitted some motions, and I'd like to schedule them for hearing.
Yeah, other than to say, well, this is a little bit time constraint. I got a pretrial on the 10th, and I want to get this motion heard before then. You know, that might make them more inclined to, if they were inclined to help you at all, to schedule it at the next available. And what do you do when you walk in there and to this motions hearing, and say, and the judge says, we're here to hear a motion from Ginger about to hear a motion from Ginger. Ginger, would you like to make some oral or argue your motion?
Yes, sir. I have a motion
No,
to...
sir. No, sir. No, sir. My motion contains everything that I need to say. If you have any questions, I would be more than happy to explain anything that I can. That anytime you make oral arguments about your motion, your oral arguments supersede the motion, the written motion.
Oh, so I don't want to counteract any of that shit that's on that paper.
You don't want to modify it. I'm not sure how that works, but you would think that if you scheduled it for a hearing, that would prod the prosecutor to make a or reply to the motion. You know, reply in opposition to the motion to whatever the motion is that you submitted, because then he could get his in there too, and then we can discuss it, can't we?
So I got to get a motions hearing in now.
Yeah, it shouldn't be too hard. I don't know. Like I said, I learned about it after I did all my shit, you know.
So if they go there, they ask me about it. Would you like to make anything? No, the motion speaks for itself.
I'm here to answer questions answer any clarifying questions you may have on it.
Oh, that's tricky. Now I have to know what questions to actually answer and what to hold back.
Hey, you know the motion.
Motion to dismiss?
Yeah, whatever it is, whatever motion you put in there, you wrote, son of a bitch. You know what it's all about. If they have any questions about the wording or the content of the motion, they're fucking stupid. Oh yeah, we were kind of out in left field. We got off on a sidetrack about motions and how to submit them and how to schedule them and all that shit. So, is the judge back yet?
I think that is a no.
I think that's what he needs to role play, though, is probably a motions hearing, because that's probably going to be his next hearing, actually.
If he's successful in getting him to schedule it.
I didn't even know that I had to go and get those motions stamped and certified. But you see, I went down to get them stamped and certified. They're like, all we can really do is just like mark them received.
I was going to say, as long as you get time stamped and get a, but they actually, when we did ours, we got them time stamped, and before they were giving us actually a complete copy of the motion. The last time we went down, because we've been filing so many motions with them, they would only give us the first page with the timestamp on it. After that, we had to pay $1 a page to get it. Although we didn't give the prosecutor the timestamp. When we had the timestamp for us, he got a copy, and then the one I cared about being timestamped was the one the court got.
On my motions, they have like received and then just the date and then her initials underneath it. It doesn't have actually a time.
How important is it to get all of them time-stamped, like the one you, or whatever, filed, stamped, received, like the one you give the prosecutor to? I've never done that.
screw him. He can figure it out himself. You're sending him a copy, and that's what you write on that little certificate of service in the back there, which you have to include with your motion to the court too, so that they're assured that the prosecutor's not left hanging in the breeze about it. Right. So what you need to do is tomorrow go down, or just call the clerk's office and ask them about the procedure for scheduling a motion. You don't even have to tell them who you are and you got a motion in there already. Just ask them about how you go about scheduling a motion for hearing, and she'll probably say, "Oh, what day do you want it?" And then you say, "Well, what motion days does the court have?" Because usually they, like I said, they set aside a day or two or so during the week or the month to hear motions, and schedule it for the next available hearing. Then if she says it's May 15th, you can say, "Well, I got a pretrial on the 10th. Is there anything available earlier?" That kind of thing.
So, James, are you saying that we should schedule motions hearings because what's happening is our motions are just getting denied and we aren't even there? Is that why you're saying to schedule motions hearings?
No, they're just getting sat on. To be, heard at their convenience instead of yours. I mean, if you go in there with a motion to dismiss for lack of jurisdiction or something like that, well, then that would obviate the need to go to a pretrial conference, right, or hearing, or a trial at all.
And you should have the right to be able to get the information from that denial or granting of that before you have to prepare for the next thing.
Yeah, I don't think they have to give you a reason. We always request full finding of facts and conclusions of law, and it usually ends up because I said so,
I snuck in.
The motion of the day is that I'm trying to prep for whatever I have coming next. I guess we've already assumed that I will be calling to try to schedule a motions hearing, so I guess we're trying to prep me for the interaction for that.
Dr. Graves in his jurisdictionary thing says that when you file a motion, you set the motion for hearing or leave it up to the court. And if you want to get it heard timely, you schedule it for a motions hearing on a particular day set certain that the court sets aside for motion hearings. Does that agree with what you're talking about or what you've heard?
Again, I'm not a ceremonies guy, but it would make sense to me that a motions hearing would be before trial. And that if a trial was scheduled, with, juror involved, it would be light and expedient to schedule it to be before that so that no one's inconvenienced. I'm okay with my motion being granted without a hearing. I've already included the arguments in the motion. It would depend if there is opposition, if it's opposed or not. If it's unopposed,
can the prosecutor make a verbal opposition to the motion?
Well, see, why not? He's communicating. Any communication shouldn't be ignored. I don't know. This is just talking.
So when you talk to the clerk, would you say, if this is opposed, I would like to please contact me. I'd like to schedule a motions hearing?
Well, no, that should be in the motion itself. Well, at least from when I read my motion, the template itself I got from Mark had that in there. If this is denied, I am requesting the grounds and the grounds on what it's denied.
The denial and grounds of denial are after an opposition and a motions hearing. So don't jump a step.
Well, she was saying if he does deny it, that was her question, and I was just saying if it does get that far as him already denying it, you have it stated in your motion that you're requesting the grounds for why it's denied in your motion.
You said denied? Not opposed?
Yeah. No, I said opposed.
Oh, opposed. My apologies.
Okay.
So basically,
what's
by
the
saying
difference?
that,
Could you clarify since I got mixed up with that? Opposed, denied.
So the difference is who's saying things. Okay. So let's just look at it as a communication. If you say, by the way, I noticed that we should get ice cream to a group of people, that is a motion. If some ice cream because I'm lactose intolerant, that is an objection. That is an opposition, right? And he says, I think we should not get ice cream, or maybe he thinks we should get frozen custard. And the judging body, let's say there's a leader to the group or something like that, or it's deny it. I hereby deny that we should get ice cream. That would be different roles. So the prosecutor can't deny a motion, and the judge shouldn't be opposing a motion. Now he can though. He can oppose the motion on grounds that the court, on the motion of a court, if he has a reason of his own, of the in the interest of the court, not in the prosecutor's interest, of course, which we know they tend to kind of walk that line and not notice. They'll make an opposition or denial or whatever.
what would be a valid reason for the judge to oppose a motion?
We know they act in the interest of the prosecutor. They deny it when what they're really trying to do is just oppose it in the interest of the prosecutor. But they have the more powerful tool of the denial, which puts a finality on it and screws with the process. So the judge tends to voice his opposition to a motion as a denial of the motion. We know that. But that doesn't mean that's what it truly should be. When he's denying the motion, he's really stating his opposition to the motion and saying, I oppose this motion and fuck off, instead of saying, I deny this motion on these grounds, when he's really putting on a different hat. And we know that. Because he's not thinking about the evidence. He's not being an independent arbiter. He's not judging the reason of the situation. He is just acting on his own whim and wishes. But if a motion's unopposed, it can be opposed on the grounds that it's frivolous, that it has no merit, right? But that would mean no merit. He would actually, if you showed any merit at all, it would show that he'd lied.
we know the judge is playing two games. He's trying to call his. Oh, I'm sorry. I was saying, so if you make a motion that is frivolous, it has no merit at all, the other side could just say, I oppose that on the grounds that it's frivolous and has no merit. That's a valid opposition. If it really has no merit, but if it has merit of some sort and it just isn't enough, and you say that, he comes back and says, motion to strike, here's an instance of merit in this motion. Motion to strike his shitty lie, and ask if he has any opposition, any bona fide opposition to this motion. So we know that they play games, however, in that they say, well, there's no merit to it, even though you've made things that are clearly with some merit, even if they don't agree that it has enough. You know what I mean? No merit means zero. Zero merit, not just insufficient. It means none. If it has some merit, you can't oppose it on the grounds that it has no merit or is frivolous. You have to oppose it on the grounds that it has insufficient merit, and then you have to make the argument. So they're being dishonest in their discourse there, and we know that. I mean, we see it all the time. But does that kind of make some sense about what a motion is, what an opposition is, what a frivolous, what a charge of the motion being frivolous is, and without merit is, and then the decision to uphold or deny, grant or deny the motion, which is supposed to be just a dispassionate thing. It's supposed to just be a weighing, a blindness. A justice is blind kind of thing. And if it's not blind, then it is not justice. And we know that. We know there's no justice from the judges, where prosecutors.
Not all just a paperwork thing to where it's like you submit the motion for discovery requesting the evidence of jurisdiction. Okay. You also submit the motion to dismiss based on their lack of evidence. Now you send it to them like, oh yeah, we deny it, and then you're like, okay, well this guy denied it, but I know this is correct, so send it to the guy higher than him, instead of having to drag you into the courtroom.
Agreed, it should be, except that there is the opportunity for what's called a hearing, the opportunity to fix any troubles in the paperwork and confusions in the paperwork. What they do is they take this right to that and turn it into a burden and a charade. They take this right to a hearing where you flush out any miscommunications and turn it into an opportunity to create miscommunications, because people are usually very bad at verbal communications and horrible at knowing when not to do verbal communications and just to stand on the written word and not to amend what they've said and screw themselves up. We tend to go in there and re-argue our motions and amend the living hell out of them and say a completely different thing than our motion. I mean, I've heard recordings, and I probably even heard in person, people go up there and say, basically what my motion is blah, 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 and fuck all. Oh my God, that's the dumbest thing you could do. And then, because the judge can tear up your motion and throw it in the garbage can as soon as you say that, because that writing is no longer valid. It has been superseded by a new motion, a verbal one, with no punctuation, no supporting document, no nothing. And he can say, I can't make sense of that. I don't know where the punctuation is. You've been unclear. I deny it for vagueness, for unintelligibility. And then he can go to you, he can make that note maybe, and go to you. I don't need to tell you why. You already know why. You were there. It's unintelligible. You stammered or restarted your sentence or whatever the hell happened. It's insane.
So they ask you if you want to make any statements on your motion, be like, no.
Yeah. Well, I mean, you don't want to deny clarification if they need it. It's like, well, is there anything that's unclear, or is there any opposition to the motion that I should be aware of? That is powerful.
Guys.
Yes.
I did that with my motions, and he just immediately denied them all. The prosecutor did not.
Sorry, you did. When you say that, what do you mean by that?
When I asked them if there was anything that was unclear in the motions, the prosecutor stood mute, and the judge denied them all.
Okay, that's a separate step, and the denial is. I mean, we know that they do that, of course, and it's a game. They're playing a game to screw you over and thwart any progress that you should be making, right? Even if you have a valid argument, they don't care. They want to deny a valid argument more than anything. So I understand. Okay, so by that you mean you asked if he needed clarification. That's one thing. And was there any opposition to your motion?
No, he didn't have any.
Okay, and did the judge? And I understand this is after the fact, but are the merits clear in the motion? Did the judge see that there was at least some merit mentioned in the motion? And did he agree that there was at least something of merit in the motion?
He didn't say. He just denied them.
Of course. Because he wants to write on the idea that there's no merit to be found in the motion. An unopposed motion, even with the tiniest bit of merit, should be granted. It's not a matter of even discretion. If it's established that there's some tiny element even of merit and there's zero opposition, the justice scales don't go to the prosecutor. You know what I mean? That's the crux of it. I don't care if he feels it's minuscule, a grain of sand worth of merit. If he wants to say there's zero merit, that's a rough judgment to stand behind. But he's not even bothering to substantiate himself that much. He's wanting to say, oh, I've listened, fuck off. That's all he's wanting to say, right? The prosecutor knows that there's this heavy bias. This judge wants to hand him everything. The only time that the judge will find in your favor is if you have overwhelming weight against him. The default is that it goes to the prosecutor. We know that. Officially, it's the default goes to the defendant, but that's bullshit. We know better. But he's trying to, in silence, just say that there's no merit, it's frivolous, whatever, and deny them. He just doesn't care for them. So I understand it's very difficult to get out of them that, do you agree that there is at least a grain, even if it's infinitesimal, of merit to this motion? And once he's agreed to that, if you can get it, which you won't, there's no denial. You can't, an unopposed motion with something of merit, there's no denying it. It shows, I'm sorry, there is denying. Obviously, physically, he can say I deny it, but it shows a bias. So it is a demonstration of bias to have granted a motion, or to have denied a motion that has at least a minuscule amount of merit that was unopposed. Absolutely unopposed. And that shows bias, and it should be stricken, and that judge should be disqualified on that alone. But again, we know that it has to shock the conscience. Well, to me, it does shock the conscience when the judge fails to give the defendant, the accused, the benefit of the doubt. He is failing to presume you innocent. That shocks the conscience. But I know they don't. Nothing would shock their conscience. They're horrible people. We know that. Okay, my rant is done. Thank you.
And that's an excellent point. The last point you raised, Gary, about when they deny a motion that's completely unopposed, it has merit. That's one of the things that's important to go into a motion to disqualify, that I forgot to word that specifically in my motion to disqualify, and I should probably go back and revise it. But I put in there that the judge repeatedly picked up the burden of the prosecutor and did all these other things.
What do you mean by that? Could you explain that to me? Because that's a little vague to me.
That she asserted that the prosecutor had presented evidence sufficient to overcome my motion to dismiss.
The phrase, picked up the burden for the prosecutor.
Yeah, that it's the prosecutor's burden to provide evidence to overcome the motion, and when the judge just assumes her burden for her and asserts that she has provided evidence to overcome it, and that she has provided evidence of jurisdiction, and denies the motion without any grounds, and you get...
No. When you say picked up the burden for the prosecutor, to me that kind of indicates that he met the burden for the prosecutor, like he did the job for him, which is a little different than saying he ignored the burden. You know what I mean?
Okay.
And didn't put one on the prosecutor. So I'm trying to figure out the difference. It's always made me a little himself. So I've been trying to figure out, and I should ask him when I'm talking to him sometime, but it's usually like either on a show or something like that where it's not easy to just, change gears into something like that, But wouldn't that mean he picked up that chore and did it? Not that he struck it and didn't do it and didn't require it,
It's a good point.
The Constitution, you just hold that up and it stops bullets and fire and terrorists and everything.
Pure fucking nonsense.
Are you saying that no court has any? There's no court that has jurisdiction, Gary?
I didn't say that. I can think of a court that has evidence of jurisdiction right off the top of my head.
Which is what?
Military tribunal.
Yeah. Okay.
If you ask a military tribunal what evidence they have of jurisdiction, they will probably have in their hands already a file with your signature on a piece of paper that says, I voluntarily submit myself to all courts of martial, and yada, yada, yada. And that would be pretty damn good evidence of jurisdiction, of persona.
Because I got something like that with my signature on it. I get what you're saying.
I'm not saying it has to be a signature. I'm just saying that's what they would use in the military. There is another way to acquire jurisdiction over somebody. That probably isn't relevant here, because if a victim of yours, someone who you have injured and caused damage to through wrongdoing, brings you into court, a whole different question comes up. But I'm trying to avoid that topic because that's a different topic. And you don't have, again, you can't reach to right and wrong when you've already been shown to have denied somebody justice. You've created a victim. You can't suddenly discover ethics. I mean, a victim can pursue his own justice. You know what I mean? And we're not talking. I mean, I'm trying not to talk about malum in se at all, because it really doesn't. Challenging jurisdiction and a malum in se thing is a completely different ordeal than what we're talking about here.
Then why are and I think maybe my thing is where I'm not, I guess, getting lost, where I need to understand as well is, if this is the situation, because it is, for example, I did take it upon myself to read Arizona Rules of Criminal Procedure, and where it states, and everywhere it states, lack of jurisdiction or challenging jurisdiction can be brought up at any time. There's no limit, ever.
So obviously they're aware of the concept, right?
But with that being said, why is it that why is it that they continue to do this if they don't have jurisdiction, and why are they fighting so hard?
Here's why. Here's why. Keep in mind that what is legal is only the opinion of the top bar person involved in an issue. It has nothing to do with reality, and it has nothing to do with ethics. It sometimes is inspired by reality and ethics, but it is merely the opinion of the top bar member involved. And don't think of it as anything more than that. Their interpretation of laws doesn't have to comport to any reasonable reading of that same thing. They could interpret it to mean the opposite of what it clearly says if they feel like it. And it's easy to do. It's just, I interpret it to mean whatever I feel like it means. Because it's their feelings, it's their opinion that's being asked for in legal issue. And so you've read all these things that in black and white clearly say blah, blah, blah. And it's like, wait, that's your interpretation. Someone can come along and your interpretation is probably fantastic. Well-read, English, clear, decisive interpretation, right? But that doesn't mean that they're not free to interpret it however they feel it should be interpreted. And that's why the legal bucket is such a, trying to argue legal issues and trying to rest upon legal interpretations, it's all discretionary. There isn't anything in legal parlance that isn't discretionary for someone. It may not be, he might have other rules that he's supposed to interpret with coming from his bosses and his boss's bosses, but it's not your interpretation that matters, and it's not clear English that matters. It is their structure that they have. So that's why we tend to focus on evidence. Evidence means the reality bucket. We focus on ethics. Justice is in the ethics bucket. And they try to substitute their crap for both of those. We're looking at evidence and justice, due process. Let's call it due process. Might be a little less confusing. Evidence and due process, aka reality and ethics. And they're trying to substitute their legal opinions for both those things. And that's why I said we're really trying to divide those up again. Say, I'm trying to talk about evidence here, not legal opinion. Is there any evidence, aside from legal opinion, is there any evidence, not, again, changing to legal opinion, that it is true that this court has jurisdiction? I'm familiar and aware that both the judge and the prosecutor are of the opinion that this court has jurisdiction. Is there any evidence that would show that they are coincidentally true? They're coincidentally correct, I should say. Because if they're not using evidence to show them that it's true that the court has jurisdiction, if they're right, it's just by coincidence. Okay, procedural due process versus substantive due process. I know you discussed it. I was doing something else, so I'll probably be repeating something. But okay, procedural due process is the legal mechanisms by which they make sure, supposedly, that they're doing substantive due process. Okay, so I'll discuss that. Let's just say that's the paperwork shuffle. That's the bureaucratic mess, right? Substantive due process is essentially synonym for ethics, justice, pursuit of justice, and not doing wrong, and not being negligent and injuring someone. So the real heart of everything to me is substantive due process. Procedural due process is very important to lawyers. And in fact, they'll try to trip you up and get you to try to provide the prosecutor with procedural due process. And that is not appropriate before trial, to me. Once you've been arraigned, you owe it. But until you've been arraigned, I don't think you owe the prosecutor procedural due process. Now, where you're talking about the paperwork shuffle and being given this notice and that blah, 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 that is sometimes of use, but don't get it from substantive due process, aka being treated right, ethical pursuit, not being treated unjustly.
Because from what I've always learned about the court of law, they give a shit about and have to care about treating right. But
Correct, because they have many tricks to get you to abandon worrying about being treated right. Court is 99% distracting you from insisting on being treated right. And getting you to, in some way, be persuaded to accept your abuse. As horrible as that is.
Thinking that you had to accept the abuse, and that's why I'm glad that I'm on here, because you're explaining to me, no, you don't. There is, there are accountable things.
Yeah. Don't be distracted. Continue the conversation of the abuse, and continue the question about how you can achieve substantive due process And they keep trying to get you to forget about substantive due process. They hate it. They hate it as a topic. They wish it didn't exist. You have the right to be informed so that you can make a knowing plea of guilty, even before trial. See, we're talking about before trial. You have the right to be informed so that you can make a knowing and informed plea of guilty. Otherwise, yeah, why not wait? They'll inform you eventually before you're required to cross-examine.
Okay, you've been charged with intoxicating yourself with intoxicants. You've already spent some time in jail. We're here. We need a plea from you. We need to find out if you're going to go ahead and have an attorney represent you so we can go ahead and move business along. Now, do you want to spend more time in jail, or are you going to go ahead and finally cooperate?
I'm going to plead guilty right now.
All right. Now we're going to go ahead. We're going to set a trial date. Well, actually, before the trial date, are you going to represent yourself, or are you taking the court discretion on getting yourself an attorney? Because obviously you can't represent yourself, based on your last transcript that I read. But I'm still offering the same courtesy that the court has for every person that's been in the same shoes that you are. You are hereby able to be representative of yourself, which I advise against. Not giving legal advice, just simply saying that you might want to have an attorney on your side. But then again, these are your choices alone. I cannot make them for you. I just need to make sure that you are competent and can go ahead and enter a plea. So you've already pled guilty.
No, I intend on pleading guilty here today. I just had a few quick clarifications.
We were not going to go through this again. We've already clarified what you're charged with. You've spent some time in jail, and we need to get this moving on. We can't take any more of the time up. I know you really don't want to have any more time that's going against you. We have business to handle today, and we need to get to the business. So will you be represented by an attorney, or will you be representing yourself?
I'm here to handle business. This is my business suit. This is my business tie. I'm here for business.
Okay, great. Glad you're here for business. So will you be proceeding on your own or with an attorney?
Well, I was just wondering, do I have the right to make an informed plea of guilty today? I would like to get this over with today.
Well, I believe from the record you have already entered a plea. We just need to simply find out if you're proceeding with an attorney or if you're going pro se on your own. You've already been advised of the risks, and we honestly just do not have time to continue leisuring you at our expense. So please do not take any more of the court's time or proceeding with an attorney. Okay, great. Glad you're here for business. So will you be proceeding on your own or with an attorney?
Well, I was just wondering, do I have the right to make an informed plea of guilty today? I would like to get this over with today.
Well, I believe from the record you have already entered a plea. We just need to simply find out if you're proceeding with an attorney or if you're going pro se on your own. You've already been advised of the risks, and we honestly just do not have time to continue leisuring you at our expense. So please do not take any more of the court's time, and you will not have to spend any more time incarcerated, which I don't believe was a pleasant time for you.
Just to clarify, are you telling me that you can accept a plea that is uninformed and involuntary?
Well, the pleas that we will accept is guilty, not guilty, or no contest, and it will be coming voluntarily from you. Of course, we need to make sure that we get this plea in so we know how we're going to proceed here today, Mr. Bryant. We need to continue. We need to get this moving. I need to know, are you going with a lawyer or without a lawyer? Because you have already entered a plea of not guilty, and obviously you're going to trial.
I didn't enter that.
We were with I believe, Judge so-and-so before I had to take over matters. He had some personal business he had to take care of. But you did enter a plea at your last hearing from my records that I'm showing. Is that correct?
I don't know if that's entirely correct. Because
what do you mean it's not correct?
Coerced. Is a judge permitted to coerce a plea or to accept a plea that is uninformed and involuntary?
Well, that's what we're here to do today is to accept a plea and find out exactly how you're trying to proceed from here. Mr. Bryant, we are trying to help you as best as possible, but I am not your lawyer, nor am I representing you. We need to move this along and make sure that you are well within your rights to do what you need. But I need your decision before we continue, if you're continuing without a lawyer or if you will be representing yourself.
I have to object. If you would just
What are you objecting
give me
to?
a simple yes or no, then we would have already been out of here and done with this.
Yes, you have a right to plea here today. That's what I'm trying to find. I'm trying to find if you're continuing the trial or if you're pleading guilty.
Do I have the right to make an informed and voluntary plea?
Well, any plea you enter will be voluntarily, and you've already been informed of the charges that are here to you. Do you need me to read them again?
That's not the question that's not relevant to what I'm asking.
It's not your opinion to determine what's relevant or not. All that's relevant right now is, are you proceeding with or without an attorney, Mr. Bryan?
I'm not interested in an attorney at this time.
All right, so you're continuing without an attorney. So you will be representing yourself.
Objection.
We will then continue. Objection
Did I say
to what,
I was
Mr. Bryan?
representing myself?
You said you do not want an attorney. If you say you do not want an attorney, I will mark down that you do not want an attorney and that you will be representing yourself. Is that correct?
To that.
Well, then please tell me, how do you want to proceed?
Counsel at a later date.
So you want to seek counsel. So you're going to go ahead and you're going to seek counsel. No. We will schedule this hearing for a later date.
Objection. I reserve the right to seek counsel at a later date.
Okay, so do you want to continue on your own or with an attorney?
Objection. Do I have the right to get clarifications without interruption?
It's about damn time, for fuck's sake.
Gosh damn, about damn time. I don't understand what you mean.
Again, that's not responsive to the question I asked. If you solely want to interrupt me and try to coerce a plea, then I'd rather
look, I'm sorry, but I'm trying to get my point across. I'm trying to find out exactly what you're trying to do here, how you want to proceed, whether you want to proceed with an attorney or not, Mr. Bryan. I'm really trying to hold my patience with you, but you're trying the court's patience. It's unfortunate that we are doing our best to inform you, but if you wish to continue on your own, plead not guilty, we will go ahead and get you an attorney. You can pay for one, or we will assign you one if needed, and then we can continue from there. But if you want to continue, I need to know if you want to continue on your own, so we can get official business in, or if you're going to continue the shenanigans with the court. So, how do you want to proceed? With or without an attorney?
I object, and again, I intend to plead guilty here today, as I've already said.
I know your intention to plead guilty here is today. We understand what your intention is, but my intention is to find out from you what you want to do, with or without an attorney. What is it? Mr. Bryan, did you hear me?
I object to that. Do I?
Object to what? What are you objecting to? There's no reason to object to this. We're just simply trying to find out how you want to proceed. Are you objecting to proceeding? Because I can't have you objecting to proceeding. That is not cooperating with the court, and that is very definite ground to hold you in contempt again if needed.
I object to that as well. And I'll thank you to not threaten me. So do I have the right to enter an informed and voluntary plea here today?
Your plea to be voluntarily entered, yes. And I've already informed you of the charges that you are faced. You are here under the charge of being intoxicated by alcohol, and you have multiple different times charges that you're facing, and this just really doesn't look good. You already have one contempt. You've been in jail for, that's paper somewhere right here, but you've already been held in contempt. Do you want to be held in contempt again? I'm trying to be the fairest judge that I possibly can, but you just don't seem to be wanting to cooperate with the system, and we need to move on with business. Mr. Bryant, I will ask you again, how do you want to proceed?
You keep saying that you've informed me. Is that an arbitrary opinion, or is it based on facts currently within your knowledge?
It's based on facts. You are charged with I'm looking at the citation that the officer has charged you with right here. And you were publicly intoxicated driving a motor vehicle in this state. That's grounds for that's breaking the law, allegedly. Now we're just simply trying to see how you want to proceed with this.
So I'm going to write that down. Give me just a second. The judge says I've been informed and it's based on facts. Okay, so what facts do you have that I've been informed?
Do you have a copy of the citation? You have been read the allegation and the charges of the complaint that has been before you. You have been in this court beforehand with another judge presenting your trial or your statements, and you are unwillfully cooperating or unwillfully participating against the system, and this cannot continue any further. You need to let us know how to continue. Otherwise, we will make that decision for you. And then we have all the means, if you're not cooperating, to put the decision in for you. It's of your own best interest, because obviously you want to fight this. And it's not that you can fight it here in front of me. No, you're not going to fight it in front of me. Like, I'm not the one you're fighting it in front of. You have the right to a jury trial, you have the right for a bench trial, and you have the right to an attorney. Now, I need to know, will you take your right to attorney or not?
Objection. Are you telling me that that's all the information that I'm allowed to have is a copy of the ticket?
No, I'm sorry. You have one final chance. Your games with this court are not being tolerated, and I've tried to be as nice as possible to you. I need to know how you're going to proceed. We already have your intent. You want to plead guilty. You don't want to plead guilty. We can't keep going in circles. Do you want to proceed with a lawyer, or are you pleading guilty?
Well, how can I get counsel if I am not allowed to?
Do you want to
be
fight this? Yes or
informed?
no? Mr. Bryan, are you trying to fight this charge against? Are you trying to fight these allegations? Or do you want to plead guilty here today?
Have I not made clear my intention to plead guilty?
Yes, you've already made your intent clear. You have already made your pretense clear that you do not want to comply with this court. Bailiff, I am now imposing a contempt of 42 hours to be held out immediately. Mr. Bryant, you take your time to go ahead and get what you need. We will enter.
Objection.
That you will
Point of clarification.
No, you have already had your objections. I am sorry, but it is clear to this court that you are not competent to go ahead and continue on your own. You failed to follow the procedures that are stated out in front of you. Within this court has a jurisdiction to go ahead and follow the proceedings that you were irregularly trying to obtain are not within this proper court procedure, and I hereby find you in contempt to serve the sentence immediately. Thank you. You're in jail, bitch.
You kept on bringing up number 1, never number 2 or 3.
All right, so we just got done with the role play.
What up, Gabe?
What up? Yeah, that was good, Ginger.
So what do you got on your tactics or your thoughts?
Yeah, I should have definitely been using the 2 and 3 as well. Yeah, I was trying to get him to answer the damn question, the clarification.
And why wasn't he?
But he's a judge, yo. Judges are OG.
We just have to be sneaky skillful about it as opposed to fucking bull in a china shop. So, what could you have done that would have been more OG?
I'm not sure. Use the 2 and 3 more, and
what I would say is that at some point you need to just switch gears, realize you're on a dead end for that track, and maybe back out a few steps on that same track, the absolute least you need to do at some point is word the same question completely differently.
All right, so your abilities with a judge who's just going to run you over and talk a bunch and interrupt you to no end need work, right? So what are some things that you could do? And I don't know, I'm just wondering why you didn't do those things. You know, I mean, it was all down his path, and I didn't hear any attempts to bring it back to yours and address the bullying. Is that something that you, I don't know, have some kind of a default button against, or?
Yes and no. I mean, yeah, I definitely should have brought it up and addressed the bullying and the rush to judgment, but yeah, I guess I just didn't think about it.
It's kind of like, you know, a UFC fight. You're only as good as your last performance. And that's scary, dude. If you're letting a guy judge, whatever, kind of walk over you verbally like that without putting a magnifying glass on his tactics. He's not even letting you think, let alone speak. Is that in any way a fair hearing? I mean, we have counter tactics to this shit. You know, that we've mentioned there's nothing wrong with, because I want to hear everything you're saying and I want to make sure that I respond honestly to your questions. So I need you to slow down when you speak, and may I have a moment to collect my thoughts. Anything, you know, to break this momentum, because it's like a basketball team, you know, they're like on a 12-point streak and you're not calling a timeout. So there's calling a timeout, and then any of the 1, 2, 3 to bring it back to the element of jurisdiction. I mean, even if it doesn't make any sense and it's a total right out in the open, bring it back to jurisdiction. And, you know, he's going to either have to address it or blow it off. But either way, you win. Because you can bring up why he's refusing to even go there.
Let me put it to you this way. I was using some of the same stuff that I listened today with that shitty judge that recused himself over his confrontation with you. And it kind of went how the video went with the steamrolling, and you didn't come back against that. But that's pretty much all I was basing my reactions and statements off of. Yours was the video that Joe, and that's all I pretty much used on you, and you still didn't break through it. So that was my process as a judge just now.
Even if he was a little far, it was totally within the aggression limits. Even if some of his words weren't words that a judge would use, most of them were. And I just don't even have a problem letting it slide anyway, just because it's working on you, number one, and it's not too far off from reality, number two. It's good for everybody to hear. We're not just trying to, let's beat up Gabe because he had a shitty performance. It's not like that. So let's just, I don't know. We've identified the problem. So what do you got for solutions? Be direct. When this happens again, I'll try and focus on this, and this. Or, I mean, I don't want to just hear the right words come out of your mouth. I want you to make me believe that you're getting something out of this, and that if you had to go to court tomorrow with the same kind of asshole, you'd do a hell of a lot better than you just did. Because I think you just got caught with like a deer in the headlights. You know? Right. And once it was going downhill, you were kind of resigned to the fact that this is going downhill, not down my track. I mean, are you not bringing your A game? And maybe part of the problem is and this is totally, you know, this happens. This is common. I mean, I do it. Everybody does it to some degree. Are you not bringing your A game into these role plays? Is it kind of like, this is a B game environment? Because there's that.
No.
Yeah.
I think you guys started off like kind of messing around, and then you guys just kept on going, and I don't know. Maybe you didn't start off the right way.
Okay, so yeah, what suggestions do you have, Ginger?
My suggestion to you, go listen to that video of you getting your ass kicked in the courtroom. And go listen to it 100 times over until you get the feeling in your chest to where you're like, I will never be like that again. because there is so many tactics and stuff that the judge is trying to farm for in yours to try to see how he's going to go ahead and get it to throw you in jail. So I think that there's quite a few tactics that I learned off of those videos today, which kind of help give me the best asset against you. Go watch those videos, listen to your stuff again, listen to Joe's actual commentary on it, and you might find something that's eye-opening for you. From all of this that I hear everyone saying, you want it on your path. At some point where you're down his road and you realize you've been down his road for a while and you're just being reactive to whatever statement he's doing, remember, get proactive, as Joe said. Proactiveness is what creates winners. So you have to get him back on your track. The moment that you see that you're off, follow him a couple steps if you need to, but make sure that get back on your path.
Well, just because they mention the word contempt doesn't mean we've lost. It just means they're trying to be sneaky and threaten you, or they really do have intentions to put you in jail. But I think a contempt charge by a judge is, at least outside of the psychotic ones, is something they wouldn't prefer. Because we're never, like, fuck this place and taking a swing at the prosecutor. We're never doing that shit. So it's never, like, blatantly justified.
Night of the fight, you may feel a slight sting. That's pride fucking with you. Fuck pride. Pride only hurts. It never helps. You fight through that shit.
Yeah, you were hard on him. That wasn't fair.
That actually, I would say Joe was actually rather soft considering how much he was rambling.
You're damn right. I could have been a hell of a lot harder. And they will be if you catch one in a bad mood and he's read your notes prior and he's big judge on town. He ain't going to put up with his shit. He'll just purposely try to troll you into anger. And if your words are not effective, he's just going to be able to push you through and figure this guy's never going to amount to anything that gets me in trouble, and I'm just going to extend him 5 weeks and use this frustrate him thing, shove him to trial, see how he likes that. When we open up, all right, here we are for trial next time. I mean, I was nice. Okay, that was nice.
Yeah,
I mean, at times
have to be
I was a
more
hard ass,
effective.
but overall. I mean, if you want to be defendant, I guess I'll do judge one more time, but then after that, I just kind of want to break it up so everybody gets practice at being a hard-ass judge. The point of being a hard-ass judge is it's freedom. Be a total dick, but say what you have trouble with, like when judges say to you, just to see how the defendant handles it so you get more ideas about maybe how you should handle it. It's just, if you know his job inside out and backwards, you're going to know your own so much better. It's awesome.
I agree. You're a good judge. You're very good. But I don't like getting off the rails with these guys. I'm rusty, too. It's been a couple of years, but I look forward to it, man. Fucking try to arraign me. I want to see what happens here.
Okay, what's your charges? Do you have any realistic, or do you want me to just make one up? What case do you want to make up, or do you want to just start off as if I dragged you in here and you don't even know why? Because you can do that, too.
Yeah, I'm here because I got some letter in the mail says that violence will be used against me if I don't show up here. So what do you need?
Let's call it some old podunk matter that was like 10 years ago you never settled, and we're a broke county, so we decided to mail out letters to people and see if they can pay things that are 10 years old. How about that? Like a speeding ticket or something. Parking ticket. Parking ticket's even better.
Oh, okay, whatever. That was my intro as I walked into court, though. I got a threat in the mail. What do you want? This is how we're role playing.
Oh, you want to start? Okay. So the case number is 1, 2, 3, 4, 5, 6, 7. Mr. Alton. So you walk up there. And Mr. Alton, I see from the notes on this case that you've received a letter for a parking ticket. The outstanding balance is now, after time and interest, $425 of an original amount of $75. Oh, it seems like back in 2007. Wow. All right. Let's see. How would you like to proceed? We can either explain and hopefully get a reduction in fine. You can plead guilty and accept the fine, or you can plead no contest and we can take this matter to trial. How would you like to proceed?
Well, I'd like to pursue a guilty plea, but I would like to know if I could ask some questions first to make sure I'm fully informed of the cause and nature of the charges against me. Would that be all right?
No, we're not here to answer your questions. I'm sorry, it's not that kind of court. This is a community court, and we have, 20 people before you and 30 people afterwards, and only 4 more hours until the end of the day. So I just need your plea. No contest, or guilty or guilty.
Well, I'd like to sign a guilty plea right now if the prosecutor could put the evidence on. Oh, wait, is this traffic? Oh, can't we do something criminal? If the prosecutor
You can certainly handle this.
There's going to be no prosecutor to ticket, right?
There could be a prosecutor.
All right, okay, so there's a prosecutor. Sorry. All right, so if the prosecutor put the evidence on the table that the code and the Constitution apply to me, I'll plead guilty and pay the fine right now, and it'll all be over with.
If the prosecutor does what, sir? I'm sorry, could you speak a little slower for the recording?
Put the evidence on the table that the code and the Constitution apply to me, and that I was within the state of Florida, and I will sign a guilty plea right now, and I will pay the fine and do whatever you want me to do. Probation, whatever you want. I need the evidence first. I can't just go around paying people who say I got to pay them without demanding some kind of proof. So as long as you have the evidence, we're good to go, and I'll pay you and it's all over. What do you say? Fair enough? What do you say? Come on, Judge. Fair enough? Come on. There's 2 men here. You want me to...
No, I'm sorry. I broke character. I'll get back in. Okay.
Want the money?
What is it exactly that you want the prosecutor to put on the table, as you say?
What's that?
What is it you're asking the prosecutor to put on the table? And please do it in a sentence or less.
That the code and the Constitution apply to me, and that I was within the state of Florida, then I'll sign a guilty plea and pay the fine.
Okay? I understand that you want to plead guilty and pay the fine, so you don't need to repeat that part anymore. You're under the impression that the... Excuse me, Mr. Alton, I'm speaking. You had a turn, it's my turn, right? So let me speak. Don't interrupt me when I'm speaking and responding to you. All right, so you are saying that you want the prosecutor to put something on the table about codes and statutes applying to you. Do I understand you correctly?
Exactly.
Okay. And you realize this is for a parking infraction that has 0 points on your record, and the fine is $425 because you've waited so long. You are expecting the prosecutor to have a matter in here? The prosecutor was never involved in this originally because you never showed up for court. So I'm not sure what exactly you're expecting when you say that. Do you know?
Well, I expect the prosecutor to be able to prove every one of his accusations, and he's accusing me of being within his jurisdiction. So as long as he has proof of that, I will pay the fine.
The prosecutor is not accusing you of anything, sir.
He's accusing me of being within his jurisdiction, is he not?
No, he is not.
Well, then how do the codes apply to me if he doesn't think I'm in his jurisdiction?
Because there's a difference between the prosecutor and the state of Texas. The prosecutor is doing his job. He's not invested one way or the other. He's not accusing you of anything. Do you understand the way the system works, sir?
You're calling him the state of Texas? Or is he the prosecutor? Or is he Jim? Who is he?
The prosecutor is an officer of the court. The plaintiff is the state of Texas. That is a difference, sir. And things like this that I don't have the time to explain to you. How would you like to... Have you ever consulted a lawyer on this matter? Or would you like to just set this matter for trial and then consult a lawyer between now and trial? Which would you like to do?
Are you denying my right to be fully informed of the cause and nature and charges?
No, Mr. Alton. I'm not going to ask you a question and then let you just abandon it totally and go off on something else. That is not how progress is made. This is my courtroom. In my courtroom, I make progress.
Well, it seems like you without answering my question. So how come you get to
I don't have to answer your questions, Mr. Alton. My patience is running short with your mouth.
My patience is running short.
I don't have to answer your questions. Mr. Alton, you will be quiet, sir. And right now a bailiff is moving to your immediate right.
Not in traffic court, they ain't. They're fucking pussies. Well, down here they are. I don't know about your area. It all depends on where you are and what kind of judge you got. Anyway, yeah, if the prosecutor's got the evidence that the code applies to me, I'll pay the thing and we'll be gone. So, I mean, what do you want to do? You're going to go to a jury trial? You're going to panel a jury?
This isn't. I don't think we need to go any further because of 2 reasons. One, you're under the impression that you can interrupt a judge, and that's never going to fly. And you're not changing your mind, apparently. And 2, dude, you run more run-on sentences than most anybody I've ever heard, and there's no way in hell a judge is going to let you get away with that. He's just going to interrupt you. You're going to get pissed off for him interrupting you. You're going to interrupt, go back and forth, back and forth. He's going to troll you into anger because the weakest link in your chain of words, Mr. Alton, is your temper and your pride and your ego.
No, I'm just asking
telling you right now.
I didn't say anything. I was asking questions. Where's the evidence? And I'll plead guilty. I mean, you're the one that keeps railroading me into this bullshit. You haven't answered my question.
Exactly. You think I'm doing that on purpose? I'm doing that on purpose.
I'm not going to let
because
you
see,
move on.
you
Why
are.
don't you move on if you never answered the question?
I don't have to. Why are you under the impression that judges ever have to answer any questions of yours? Whoever told you that?
Well, because I went to court and they answered my questions, and you know
that doesn't mean they have to. That means he was nice.
I've had judges answer them. I've had judges yell at me. I've been thrown out of court. I've been charged with contempt. I've been jailed with contempt. Fuck them.
I don't doubt you. And I'm not saying that you're doing anything wrong by doing that if that's the way you choose to go for your purposes. I'm not here to judge your purposes. I'm here to keep you out of jail and to have these other people learn about Columbo, right? And the Socratic method, which doesn't involve getting thrown in jail and interrupting judges.
Well, you know, just about anybody who's done this or tried this pretty much went to jail. They're fucking locked up, or they paid the fine, or they cut a deal. You know, this thing is no foolproof. This isn't a plan to get out of this. I mean, this is just, you're just rolling the dice.
There is a way to get through it unscathed, and the goal is to stay out of jail, and there is a way to win.
What?
Absolutely there is.
Oh my God, it's on your
I've seen people do it. I've heard my friends do it. They tempted within a word of going to jail, recognizing it, and skillfully dodging it, denying the judge the ability to do so, despite his very best efforts. That's called discipline, good training, practice, and knowing the craft. It's
some judge
communication.
from town I give in, he proved there's no evidence of jurisdiction, drop it. Dismissed for lack of evidence of jurisdiction. I'd like to see that fucking paperwork.
Okay, go ask Scar. He got one just a couple days ago. That's exactly why it was dismissed. They just changed their fucking mind. He denied it, and then he said, "Oh, I changed my mind." No reason. And it was for jurist freaking diction, dude.
He wrote it in there, lack of jurisdiction, that's why?
No, he said it was because of the motion.
He got his motion approved? Granted?
I don't know how long you've been out of the game, but things have changed, man.
It's a couple years, but I'm just saying it was granted. The motion was granted to dismiss based on lack of jurisdiction.
You just got a victory. Look in the No State Project chat. And it's because he got a big freaking win.
If somebody actually got it thrown out on basis of the lack of jurisdiction, that would be wonderful. I'm all for that. I just haven't seen it yet.
And I'm trying to show you how it's possible, but you're telling me I'm wrong.
MarkStevens.net. Look under their success stories. They're the recent Texas one
Hell
of
yeah.
a docket number that is specific that can be verified by entering it into the government website, and it'll verify that the jurisdiction of the prosecution was not verified nor proven beyond a reasonable doubt. Therefore, they have dismissed the charges.
Well, that's awesome. Everybody should be carrying that in their fucking pockets when they go to court.
Yeah, dude, there's a lot of success stories. But
He
even
gets
throwing
10.
out Supreme Court rulings in favor, these judges still take it upon their liberty to blatantly disregard a Supreme Court ruling when it has been factually identified and stated in front of their faces on the record. They blatantly disidentify
They can do whatever they want. Yeah, steamroll, whatever.
I've brought Supreme Court shit. They about laughed me out of the court.
Yeah, because you can go into any law library, go look up the books, and find Supreme Court cases that just directly contradict each other. So it's like cherry picking, and they know it. I'm really not honestly trying to win an argument against you or be right or prove you wrong. I'm not trying to do any of that. I just have other people here listening. Maybe things have gotten a little more aggressive or whatnot. I don't discount your previous experience. It's something I don't have. I'm sure there are things that that I need to learn myself. But I'm just telling you, they're not going to put up with this shit of interrupting. And if you want to go to jail, then just keep doing that. But nobody here wants you to go to jail.
No, you got to understand, man. When the judge interrupts me first, then I'll interrupt him right back, man. It's all tit for tat. I'm sorry, but it's just another human being. I don't care what dress he has on, what he thinks he is, or what he thinks his fiction is. I don't give a fuck. It's just another human being in front of me, man. And if you're going to interrupt me, I'm going to interrupt you. And if you want to lock me in a cage because I interrupt you, that just makes you a fucking criminal. I'll go toe-to-toe with any judge and any prosecutor and any cop. And I've gone toe-to-toe with many cops, man. And I'm telling you, if you call them on it, they back off. They don't respect anything except another barking dog. I'm telling you, they're fucking assholes. They're going to run right over this other guy, this last guy.
I'm agreeing with you, actually. I mean, I'm agreeing with you, but in a way that says, all right, well, you apparently need to be thrown in jail a few more times, and then you'll be back here going, how the hell do I stay out of jail?
Well, no, I never did.
I can't convince you right now otherwise. You sound set in that way. I'm not even going to try and change your mind. I respect you're a grown man. You can make your decisions. It's all good.
All the judges I've been through, they've all been different. They switch judges on me over and over and over again. I got a new judge.
They do that on purpose so that you can't figure out his ways and use it against him. But they do that on purpose. They rotate judges just to keep you off guard,
Well, that's weird,
especially
'cause I
us
look at
when we
these other
come in on
stories.
evidence of jurisdiction.
I look at all these other stories, and it's the same judge and the same prosecutor for 3-4 years. You know, how come I have 5, 6, 7 prosecutor judges and they keep switching them because they can't answer the question?
I'm on my 1, 2, 3, 4, fourth judge in a courthouse with only 5 judges in it, and I have tiny misdemeanors.
Yeah, but
so they rotate the fuck out.
Did you keep fucking them up, and then they had to switch a judge on you, or
No, absolutely not. I just went in there being effective, and they don't like it, and they can't stand it. They keep switching.
Well, why
they pull
switch
me out of line alphabetically and throw me at the end, and then find a reason to an extension, like, oh, you asked for a bathroom break because you've been waiting for 45 minutes. Nope, sorry, we need an extension. Oh, sorry, we had a trial before you, and that's not fair, but oh well, too bad, fuck you, come back in 5 weeks. I'm drawn off of a lot of hearings from people, a lot of different places. To get a dismissal letter is a beautiful, beautiful thing worth something that money can't buy and you can't quite explain. Things like that universally have a high price, and the high price for you is going to be your pride and your ego and putting this thing away about, he's just another man, and if he interrupts me, I'm going to interrupt him. That's one way to go about it. And again, I'm not judging it like you're wrong. I'm just saying a Columbo approach makes the judge furious, not you. Through skillful communication, you accept all of his interruptions, and you just use a magnifying glass to point them out. The public can hear it. It's all over the transcript. The judge gets pissed because he knows you're being effective on the transcript and that you've got awesome grounds for appeal. And he doesn't even need to know that we hate appeal and don't want it to go there. He's still afraid of it because the only thing they give a fuck about is that transcript. And once they get a tiny whiff that you are trollable, you're done. And you know what? You might as well be a slave to yourself because you don't even have a choice in the matter. You're just on autopilot. I'm going to interrupt because I have an ego and fuck this guy. I get that.
The judge, you were playing the judge. You interrupted me, man. You're getting this all fucking backwards here. Wait a minute.
On purpose. Welcome to reality.
I've been
Welcome
to
to reality.
fucking times, and I've never been interrupted by a judge. I don't carry myself like that. I go in there and I look them dead in their eyes and I ask the questions that need to be asked and I demand evidence. I'm not rude. I'm not obnoxious. I have no ego. Okay. I just want to get this over with. I'm very nonchalant while I'm in there, okay? But you interrupted me and no judge has ever interrupted me. I've always been able to finish my sentences because I don't go running on with bullshit.
Yeah. I would like anybody else in the room.
Are you fucking kidding me,
please,
Alton?
Yeah.
You've never been interrupted by a judge? Every judge I've gone in front of has interrupted every damn question I've asked or clarification I've asked them.
And he's as nice as they come.
And they pretend like they stop talking and like they're done. And as soon as you start talking, it's just like they start continuing a sentence that they never...
No, they ignore me. But I'm saying they never interrupted me. They just ignore me and move on.
Did you...
they never interrupted.
Were you ever effective with pursuing the evidence of jurisdiction?
Oh, yeah, I
or
asked
did
for
you,
that all
did you
the
have
time.
other... I'm sorry, go ahead.
I ask for that all the time. I asked for evidence of jurisdiction. I asked the fucking jury for evidence of jurisdiction. I fucking held out the guilty plea and said, I'll plead guilty right now if these guys can just prove that the code and the Constitution apply to me and that I was within the state of Florida. And we'll get this over with right now. Not that I'm guilty of anything, not that I've done anything morally or ethically wrong, but I'll sign a guilty plea because if these laws do apply to me, I would never fight these people because everyone who fights them loses.
So what happened in that case where you weren't interrupted and you did push forward evidence of jurisdiction? What was the end result?
They just railroaded me right into a jury trial. That's all. They didn't.
And what happened at the jury trial?
They just judges and everything.
What was the end result? The decision?
Well, it ended in a mistrial. It's over. It actually had to go to the appeals court. The state attorney took it to the appeals court, and then the appeals court sided with me.
So you've beat them. It just had to go all the way to appeal.
Yeah. It ended in a mistrial. They didn't like my questions.
What caused the mistrial?
They didn't like my questions, and they were losing. It looked horrible for them. A mistrial was the only way to get another bite at the apple. And I had a libertarian woman on the jury, man. She was slobbering all over me. She was on the edge of her seat. She was never going to let them convict me. And the prosecutor saw that and knew that. Oh, everybody knew. I walked out there, my mom, my sister, and everybody like, did you see that blonde? She ain't never going to convict your ass.
It's pretty funny that a lot of people would pick that up. That's pretty funny.
Oh, it was obvious. When I was talking to the jury, I was making, she never...
All right, well, I hope that you prove me wrong. And
I don't want to prove you wrong. I want us all to beat the shit out of you every time we go. I don't want
to... I was making a joke. I was just saying I hope the judges... You're right, and that the judges never interrupt you, but I bet my life that you're about to get surprised.
But they never interrupted the point I'm trying to make is they didn't have to because they just ignored me and moved on.
Keep in mind that when there's a critical difference between being in front of a jury and being in front of a judge. And of course that is that the jury aren't bar members, they're not skilled in manipulation, they don't really supposedly have a dog in the race. Yeah, they're sheep and probably want to conform to the judge. They might have still humanity, compassion, empathy, the ability, they're human fucking beings.
Yeah,
So,
but
and
wait a
that's
minute.
such a critical difference because you're going to get treated differently in front of a jury than you are in a regular traffic court deal.
Of course, yeah.
Big
but
time.
You got to remember that
Big
the jury
time.
is also threatened with violence and paid money by the prosecutor, the other side, the option, the whatever.
Yeah,
your
but
opposition. Your
I
opposition
don't want
is paying them. And
Right.
he's threatening them. If I paid them and threatened them, what would they do to me? That's not.
No, I understand what you're saying, but I don't want to just blow past the point. You're coming to the role plays here where we're going in traffic court saying, I'm not going to be interrupted because I wasn't interrupted over here and I've been to the jury trial. And I'm telling you that it's likely that you'll be less interrupted in a jury trial because you're in front of a jury and the court knows that the power is with them. They can't be punished if they say, fuck you, judge, I'm going to do whatever I want. And then because of double jeopardy, they can't just throw out their verdicts and just because they didn't like it and just start over.
Well, agreeing with you, I tell you what, the jury it was the only time I was free to talk and was able to actually talk and keep talking.
But the point that I'm trying to hammer on is you can't have the same approach going into the traffic courts, misdemeanor courts, and our role plays here because we're trying to be Socratic method in Colombo because that's what's effective. We get interrupted like a motherfucker in here. There's no jury around to make the judge be nice, okay? It's good enough. All right, Mr. Ginger, what charges are you going in on March 10th?
Speeding, 65 and a 45, and possession of drug paraphernalia.
Oh, way to be.
I have
All right.
already entered a plea of not guilty, obviously under the threat of duress or coercion.
Oh, so we're at the next hearing, and what's the title of your next hearing called?
Pre-trial hearing.
And they gave you a pre-trial hearing because why?
Well, because I entered the not guilty on the arraignment, and in their eyes, I've already been arraigned.
Alton, I can't hear him over you, dude. If you got something to say it in the chat box, and I'll totally hear it, but I can't hear these people when you're talking. Go ahead, Ginger.
Pre-trial hearing, I have already pled not guilty at the arraignment.
Yeah. Why are they giving you a pre-trial hearing? That's not a reason for a pre-trial hearing.
They're giving me a pre-trial hearing because they said that was when I was going to be able to ask questions, be informed, and blah, 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 blah.
Oh, so they used it as an excuse to push you through and not make them look too horribly bad or a bully. Okay. All right, are you going to get the same judge, do you know, or not yet? Not
as far as I know, it's still going to be the same judge.
Okay, and on a scale of 0 to 10, how big of an asshole was he or she?
I can't rate that intelligibly.
No problem. I'll make up my own. All right. So here you are, Mr. Ginger. You've got the charges read to you. We're at a pre-trial conference. You understand you had a plea of not guilty, and we're here to further, questions on the matter. How would you like to proceed?
Do I have the right to plead guilty here today?
Yes, you do.
Do I have the right to an informed plea of guilty here today, sir?
You've been informed.
Objection, point of clarification. At what point has the prosecution submitted evidence of jurisdiction?
I didn't mention anything about jurisdiction, so I don't know why you're having to clarify something brand new. Are you asking me about jurisdiction, something separate now? What's going on here?
Objection, point of clarification. At the last hearing on April 4th, I had some questions that I tried to put in front of the court. I was rudely interrupted.
Right. Time out. I'm going to take a quick time out here. So, objection, point of clarification is to clarify something the judge said.
Mm-hmm.
If you treat point of clarification as I want permission or I'm just going to take the mic and go off in another direction, even if the other direction is valid, and I'm not saying it was a bad direction you were going in, I'm not speaking to that at all, the judge is going to give you shit and think, worst of all, that you don't know what you're doing. That is not the impression we want to give a judge. So just remember, if you're going to make objection, point of clarification, fucking clarify. If you're not going to make a clarification, then don't say clarification. And if you don't need to make an objection, then don't. If they just give you the microphone and you're ready to go off in another direction, just take it. You only want to use objection if you absolutely have to, because they're going to get sick of you if you use it all the time, inappropriately especially. We'll practice that. If you screw it up, who cares? No big deal. I'm happy that you're making screw-ups here, but I'm going to call you out on it. All right, let's continue.
Where were we at?
Timing. I would just say we're here at arraignment. Let's see. Whoa, how do you proceed? That's where it was. How do you want to proceed at this pretrial conference? Do we have a plea deal on the table, Mr. Prosecutor?
He's not going to ask you that. That's ridiculous. He's going to ask you if you're ready to go to trial. That's what he's going to ask you. Are you prepared for trial?
I'm sorry. What is he not going to ask you?
He's going to ask you if you're prepared for trial. That's what a pretrial.
No, you said that he wasn't going to ask you something and it was ridiculous. What were you referring to? Clarification.
Yeah, plea deal on the table.
What?
Don't think that they're going to ask you for a plea deal on the table at a pretrial conference because your opinion is that's ridiculous.
Pretrial? What are you talking about? No, you're talking about the pretrial conference is just see if they're ready to go to trial. That's all they're going to do. That's all they're going to ask.
No, you're mistaken.
Oh, really? Okay.
Yeah.
What kind of court you
probably
got?
Talking to a guy who's heard more judges speak from various parts of the countries than all of the rest of you combined over the last few months.
Been in court?
That's exactly what they do. If he's at a position where he's not at trial, they don't want him to go to trial, their preference is always the plea deal. That makes them accept jurisdiction, plead guilty, and pay. They'd always prefer that over a trial. So a judge is always going to go to that first before, what do you think about going to a trial? That is not their number one option.
Well, I don't see how a plea deal would even be an option. The laws haven't been proved that they apply to me. Why would I entertain a plea deal?
As if that matters. They don't care that the laws don't apply to you. They're still going to offer you a plea deal to keep you out of trial.
Give a fuck what they do. They haven't answered the original question. Why would you move on?
Yeah, but what you care about what they do or not has no bearing whatsoever on what they're actually going to do. And what they're actually going to do is have the prosecutor come up with a plea deal.
They don't give a shit. You can't predict what they're going to do. You go into court, they're going to say what they say.
I most certainly can predict what they're going to do.
How many times have you been to court?
It doesn't, probably 15 in the last year, not to mention I've heard 4 times that many myself going over word by fucking word, and I've got a YouTube channel with like 150 videos to prove it. That's how.
Did yourself?
Absolutely.
And you got all kicked out, huh? 15 of them?
Anybody else here? Anybody else know what I'm talking about?
I'm just asking.
I've seen your channel, Joe. It's pretty extensive.
If I say a judge is going to prefer a plea deal over a trial, that's the way it is. I would never say something about a court or a judge, especially with newbies listening, unless I was 100% sure. It's this simple. If you're role-playing a judge, you can do whatever the fuck you want. You can please contribute. Please, but type it in the chat box, because I have a chat box right here in front of me, and I'll see it, and we'll get to it and address it. All right, so have we got a plea deal here, Mr. Prosecutor? Yeah, we got a plea deal, whatever. Let's just say they make something up and come up with it, or not. Let's say they say, well, we've got one in the works, Your Honor. We could talk to Mr. Ginger on the side here if you like. And then the judge goes, Mr. Ginger, would you like to have a pretrial conference with the prosecuting attorney here?
Sir, my intention here today is to plead guilty. I came with an unsigned plea of guilt.
Mr. Ginger. Did you hear me ask my question? Is my microphone on? I said, do you want to meet with the prosecutor and discuss a plea deal about these charges here today before we go to trial?
At this time, I do not wish to speak with the prosecution on a plea deal. I simply just wish to be informed on a few more clarifications, if I may, as I was cut off rudely at our last hearing, to be able to get anything clarified for me.
Mr. Ginger, and they'll interrupt you if you say something like that. Mr. Ginger, it doesn't matter what your opinion is of the previous judge or if they were rude or not. All right, the only thing before this court here, I understand that you might have strong feelings this way or the other, but the only thing before this matter here today, and for time efficiency, we need to either move toward a plea deal or a trial, however you determine. Now, if you have a few more things you would like to ask, maybe the best thing to do would just be to either find a lawyer, or if you can't afford one will be provided to you. Do you understand that?
I hear the word that you're speaking, Judge. I just want to clarify if I do have the right to plead if I do have the right to
Yes, you have the right to plea how you want, and I'm asking you so that you're not as confused. If you would like a free attorney if you need, so that they can clear these things up for you. The court does not have time to entertain such questions here today.
Thank you. I do take notice that the court is offering counsel. I do wish to decline at this time. I wish to plead.
How would you like to proceed, Mr. Ginger?
My intention is to plead guilty here today if I do have the right to
You
be
more than you
informed.
have the right to plead
of
guilty here today. Is that what you would like to do?
My intention is to plead guilty. I just simply need a few more clarifications.
I don't care about what your intention is. You're trying my patience. I need to know if you're going to plead guilty, not guilty, or no contest. I read the notes from the previous case, and I think I have an idea of the kind of roundabout you're going on, but the only problem is that you're not quite sure of exactly what you're trying to do, it seems, to the court. And that's why the court is trying to protect your interests, to make sure that your rights aren't damaged at all, and so that you can get an attorney who will help you. Do you understand that you have a right to an attorney? Do you understand that you have a right to a lawyer, Mr. Ginger?
I do understand that I have the right to an attorney and that I do have a right to counsel.
Right.
At this time, I do wish to request the evidence of jurisdiction that the prosecution has submitted, stating that the codes and statutes that I am physically in Texas apply to me.
You're asking for jurisdiction about Texas and the codes and the statutes. Look, let's take one step at a time. If you know that you have a right to a lawyer, I have a few things I need to check off. Now, you're saying that you want
Objection, point of clarification.
No, there is no objection. I'm talking right now. Wait until I finish my point, and then I'll let you speak. I will. I need to check this box off first. You say that you do not want a lawyer. And despite the fact that you sound a little bit confused on the issues, I'm willing to accept that. However, you have to agree to waive your right to a lawyer if you'd like to proceed on your own. Now, do you wish to waive your right to an attorney? Mr. Ginger.
My intention is to plead guilty here today.
Yes, Mr. Ginger, I understand, and I don't want you to repeat yourself. I understand that, Mr. Ginger. I heard you the first and second time you said that. I'm aware. Okay, but before we get into that, will you waive your right to an attorney?
I do not wish to waive any rights at this time until I am fully and adequately informed of the cause and nature of these proceedings. Now, has the prosecution submitted any evidence of jurisdiction establishing that the codes and statutes of Texas or
yes. Codes and statutes of Texas, I understand that you're having a hard time here, Mr. Ginger. And I'm not trying to, the court is not trying to make light of your situation, Mr. Ginger, or totally realize that you're doing the very best you can. But what you fail to realize is that either A, your choices are you can accept a lawyer if you can't afford one, pay for your own, or waive your right to a lawyer. If you don't want a lawyer, then you might want to waive your right to a lawyer. You're trying to skip the entire process and just go straight ahead. How can I hear anything about jurisdiction if I don't know whether or not you're adequately represented? Because as a judge, if I don't make that clear, then it's on my failure to duty to run this courtroom in a way that protects your best interest, even though you don't know what those are. So would you like to waive your right to an attorney?
Out of character, your answer to this next question will be yes. In character,
I just got done as the judge saying that you need to choose A or B, between have a lawyer or don't have a lawyer, before we can move forward. And then you said out of character, something, in character, and then went. And I had no clue what you meant by that. I'm willing to listen to you, Ginger, about what you said, what we're trying to make there, but I don't know what you meant.
You are stating in the role play that I have the right to a court-appointed counsel. In the state of Texas, I am charged with a fine-only misdemeanor. The court will not allow for appointed attorneys. So the basis of your role play,
I got you.
Taking it that route, you can't try to force an attorney on me because they will not tell me to have an attorney. They will just play stupid until I actually try to clarify myself.
So I understand now exactly what you meant. And now I remember Texas is getting screwy with this. Like if your threat is less than 6 months jail, they don't even have to provide you a lawyer now or some shit.
Yeah, in the state of Texas, under criminal charges, they said that if you are presented with a charge that has a fine of less than 6 months, so 5 months and however many days in that month, depending on whatever the specifics are, if it's that, then you are not entitled to a court-appointed counsel or court-appointed hearing. Now, that's all I stated when I said out of character, because my next question was going to address.
Okay, hold on. Whoa, give me some time to break in here. Don't, because we're out of character, right?
Yeah.
So this isn't a war of words anymore.
No.
But give me a second to respond, because otherwise I need to clarify that, and then I forget, and it's just bad communication. So now I'm clear on how you want me to set this up, and I totally can. It's a great idea. I'm glad you brought it up. I will. But I also wanted to clarify, the judge wasn't trying to force a lawyer onto you. He tried it in one sense, but overall he was saying you can either have one or you cannot, but you got to waive it. So that's giving you an option, not trying to force, right?
Okay.
So now that we're clear on that, and I totally got it, I'll change my tactic a little bit there to adapt to Texas. I'll say, okay, so because this charge is 30 days and $1,000 fine or whatever, if you'd like to proceed without the help of counsel, you're more than willing to. I'm just putting it on the record that you have been so warned. How would you like to proceed?
To clarify, would you factually identify so warned? I don't understand what you mean by so warned.
Sure. It's simply a way that judges put on the record that I have informed you that it's in your best interest to get legal counsel and that you have denied it. That's all it means. Go ahead.
Objection, point of clarification. At which point have I denied counsel?
You're saying that you want to proceed without the help of counsel, and you have not brought counsel here. Is that correct?
I am simply just trying to understand the cause and nature of the proceedings, and to try to see if the
okay. You've had
try
the
to
charges
understand
read
if
off
the prosecution has submitted any evidence of jurisdiction.
I understand. I know where this is all going, but just to make sure, you've had the charges read to you, correct?
The allegations have been stated, and I've heard them.
Okay, great. Have you a copy of the charges?
Copy as in which document are you specifying?
Do you have the tickets that were issued to you?
I have a piece of paper that the officer had handed to me, whether it's a citation or not. I'm still trying to find the validity of it.
Okay, Mr. Ginger, we need to come to a meeting of the minds here. I don't have time for all of this, so we've got about 5 more minutes to wrap this up. I'm not trying to play word games here with you. If I ask you if you got the ticket, I think you know to what I'm referring to. We don't need to try and reword everything, because not everything you're acting like everything I'm trying to do is against you. I understand you've probably got your own legal counsel from somewhere. I'm just telling you it's not specific to this court here in Texas. It's probably more broad in scope. I am trying to protect your interests because I'm the only one in this room right now who's even capable of doing so. So let's keep language simple as possible. I asked you if you had a copy of a ticket. I will understand that by your answer you meant yes. Okay? So you have a copy of the ticket, and the charges have been read to you. What further do you need to be informed of?
Where specifically the prosecution is relying on evidence of jurisdiction, sir?
The prosecutor isn't relying on jurisdiction. Next question.
Has the prosecution submitted any evidence of jurisdiction stating that because I'm physically in Texas, the codes and statutes apply to me?
No, he hasn't. Last question.
I moved to dismiss based on the prosecution's fail to prosecute. No evidence has evidence of jurisdiction has
Mr.
been
Ginger,
supplied
Mr.
to me.
If I'm talking, you're not. The reason why I'm interrupting you is not to be rude. The reason why I'm interrupting you is because you're wasting the court's time, and I know it based on what you've said already. You asked me. I have sat here and answered your questions even though no judge is actually required to. It's up to my discretion. We are here to
point of clarification.
No, I'm not done yet. You cannot not object at this moment in time because I haven't said anything that is binding to you or determines your fate or punishes you. I'm asking you to just listen. If you have an objection, make it after. You asked if the prosecutor had submitted any evidence of jurisdiction that had to do with your physical geographical location. I said no, because he has not. I told you next question. And you're objecting clarification and dismissing the case. And what grounds? And you don't even know. In the best interest of justice, I'm going to schedule this matter to go ahead for trial. You've been clear on the record that you don't know what you do. The court has warned you to get an attorney. You are choosing not to. That's your choice. Trial is going to be scheduled for May 30th at
objection, point
1:30 p.m. Your objection is noted. Trial is going to be scheduled for May 30th at
objection, point
1:30 p.m. Your objection is noted.
I wish to plead
Mr.
guilty
Ginger,
here today.
Mr.
I just
Ginger,
simply need to
Mr. Ginger, what part of don't talk when I do you not understand, sir? I take it you'd like to leave this room with your freedom. Is that right? I have listened to you speak. I'm not going to listen to you make no sense and run me over. I am the judge. You don't interrupt me in my courtroom. That's not a very smart thing to do, which is why it would be wise to look into counsel. Now, when I'm looking at the calendar, I cannot listen to you. I assume you would like me to pay attention to your words. Now extend me some courtesy. I'm looking at the calendar. When I get done, I'll let you know I'm done, and I will hear your objection. Now, 1 minute, sir. All right, it's going to be May 30th at 1:30 p.m., courtroom 3C. All right, go ahead. Now I'll hear your objection.
Objection, point of clarification. I do wish to plead guilty here today. I just need to be adequately informed. I'm sorry?
This is called circular logic. You've been informed. You've had opportunities to ask for information. What exactly do you accept as informed? This will be the last chance you have.
Has the prosecution submitted any evidence of jurisdiction stating that because I am physically in Texas, the code and statutes apply to me?
You've asked that already and answered. Next case. Done. Now, I know I was total dick, and understand that's a total act, and I'm not trying to be a dick to you. I'm feeling for you, and I'm praying for you, and I'm hoping for you, but there's a reason why I got away with all of that, and if you have any questions, go ahead and fire.
Yeah, what was I missing? I understood your clarity, but I was trying to get it out, and I didn't know how to get him. I read in the chat, box him, pounce him, box him, pounce him.
I'm really glad that this is happening here, right, and not in court, because this could very well happen in court. So to answer your question, you went on with a question about, has a prosecutor submitted evidence of jurisdiction that the codes and statutes apply just because I'm within this area of Texas or the county of whatever, okay? We don't do that. Our question is, has the prosecutor submitted evidence of jurisdiction, yes or no? The end. The reason why we don't add on the rest, and please learn from this, the reason why we don't add on the rest, especially you, Ginger, I'll say it again. The reason why we don't keep adding on to the rest is because you just gave the judge perfect permission to say no on the transcript and not be lying and not be doing or saying anything wrong. You asked, has a prosecutor submitted evidence of jurisdiction that speaks to the geographical area of Texas? Do they ever? No. No, they don't. And they don't have to, because jurisdiction doesn't necessarily mean that. In your head, it's meaning that, and you're sitting it out into the courtroom as if the court should respect that. They don't have to respect your definition of it, so don't give one. Does that make sense? That's why we leave it so vague and open. When you end it with evidence of jurisdiction, period, that they have to respond to, because you're a little bit vague, and their rules say they have to respect that word. So don't further define the word into something that they can shoot down. Does that make sense?
It does make sense. The only thing that doesn't make sense is I have notes here that are from different commentaries in the chat that I guess Scarlett and Mark's ways specifically stating the way that he trained him on that, or that's the way that he prefers to route. That question, I'm trying to use both ways to see how it works.
There's a reason for that. I'm glad you brought that up. I'm glad you asked me any question like that. But there's a reason for that. When you hear, has the prosecutor submitted any evidence of jurisdiction that the statutes and codes apply to me just because I'm in the state of Texas? They've already gone down a little bit of the rabbit hole with the judge. The judge has already tried to be vague and fuck with them because they know they're on the right path. And what that is, that's a question with a magnifying glass on it. You don't need a magnifying glass right now. The judge hasn't even tried any counter tactics and bullshit with you yet, because you made it too easy. So that's where that comes from. Now, I have heard people, and I use it all the time, where you go, has a prosecutor submitted evidence of jurisdiction that the statutes and codes apply to me, period. That I would have also found acceptable. So that would have worked then. But you don't want to get more specific unless you're using a magnifying glass, because they're abusing you, denying human rights, things like this. Does that make sense?
That does make sense.
So have that tool in your toolbox. I'm glad you got it. It's just that you were using a Phillips head screwdriver when the case needed a straight blade.
Yeah.
When I'm playing judge, I try to do what they do, which is find the weakest link
in the chain of words that you just said and use it to my advantage. And if you can't recover, if you don't know what I'm doing, that means I'm going to get away with it in the future. And I'm going to use it again and again and again. And probably in that course of that time, I'm going to find another weak link. So that even if you figure out the first one, I might already have in my head, oh, I can just jump to the second one because he let that piece go by and he obviously didn't know or else he wouldn't have. Do you see what I mean?
Yeah.
I'm just making the point to everybody, really. If you hear me pulling something new out of the hat that you're like, well, I didn't expect that, it's because I just sensed a weak link in what you just said. And the judges do the same. So take a moment and see if you can figure out what your weakest link was. Because if you can, then you can immediately address it, thereby letting the judge know, aha, motherfucker, I just saw what you did, and I kind of saw what I did, and I fixed it, so now you can't do that anymore. And now they have to go searching for something else. What other questions do you have about what happened?
Brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
But we were just for this practice one. The suggestion was go through that list of questions and see how you do with them.
Okay.
Just to practice.
Okay.
All right, Mr. Jamar, you are here today because you've been charged with speeding 56 miles per hour in a 55 mile an hour zone. This carries a monetary fine of $500, as well as a requirement for you to take a defensive driving course should you be found or plead guilty. So all I need from you today is a plea of not guilty, in which case we'll go ahead and set you up with a trial date. A guilty plea, in which case you will have to pay that fine and take the defensive driving course. Or a plea of no contest, which will have the same penalties as a guilty plea. So all I need from you is one of those three answers: guilty, not guilty, or no contest.
Okay. Your Honor, I intend to plead guilty today. I just had a few points of clarification.
Okay, well, what do you need clarified on so we can go ahead and get that plea in for you?
Okay. Do I have the right to a fair and meaningful hearing, sir?
Well, of course you do. Why would you think otherwise?
I would just like to have these questions answered so I can just make sure of that.
You waiting for an invitation? There's not a green light.
Okay, and also, do I have the right to be informed as to the cause and nature of the charges, allegations, and proceedings here today?
Well, of course you do. You have every right to be informed as to the cause of these charges against you.
Okay. And also, am I presumed innocent of all the charges?
Stop.
Okay.
What did I say? Did what I say match your question?
Okay, that wasn't a yes or no. It was a sure. I guess clarification.
No, it's not even. It was a sure.
No, it was you have the right to be informed of the cause.
Oh yeah, cause. There you go.
Oh, just the cause. Okay.
Yeah, just the cause of the proceedings.
Okay, also, do I have the right to be informed as to the nature of the charges and proceedings here today?
Why, yes, you do.
Okay, and also, am I presumed innocent of all charges against me here today?
Absolutely, sir. You are absolutely just as everyone else that enters this courtroom here. This courtroom here, everyone is presumed not guilty of all allegations against them.
I guess objection, point of clarification. Am I presumed innocent of all the charges against me here today?
And that's fine, but I like to take it a step further. Objection, point of clarification. I was trying to ascertain whether or not I'm presumed innocent, not whether or not I'm presumed guilty.
Okay.
So I'm identifying where he purposely misled, and then I roll that right back into the question. So I've identified, the error in his response. So now I'm going right back into it.
Okay, I got it. Okay. Objection, point of clarification. I just wanted to be clear with something here. You said that I am presumed not guilty of the charges against me here today. And I asked you, am I presumed innocent of all charges against me here today?
So am I presumed innocent? Yeah.
Okay. Yeah. So am I presumed innocent of all charges here against me here today?
Why, yes, sir, you are.
Okay. Also, am I presumed innocent of every element of the charges?
I'm sorry. What was your question again?
My question was, am I presumed innocent of every element of the charges?
Why, yes, sir, you are.
Okay. Well then.
Now, sir, I've entertained lots of your questions. Now, can I please just get a plea for you, or are you just going to refuse to enter a plea today?
Well, my intentions are to plead guilty today, but I just had a few other questions I'd like to ask and clarify before I enter my plea. I just want to be informed.
Okay. Future reference, try not to use the word questions, but yeah.
Oh, okay. Okay, so
and also don't wait for him to give you permission to continue on. Just go right into your next sentence. Always end on a question mark.
Okay. Is jurisdiction an element of the charges?
Mr. Shamar, I can assure you that this court already has jurisdiction. Otherwise, the prosecutor wouldn't bring such a case before us. And obviously, since you were in the state of British Columbia, Mr. Shamar, I can assure you that this court already has jurisdiction. Otherwise, the prosecutor wouldn't bring such a case before us. And obviously, since you were in the state of British Columbia, we have jurisdiction. So let's go ahead and move on to your next question.
Okay. Well, has the objection, point of clarification, has the
yeah, don't answer that with an okay.
Sorry. Has the prosecution provided the evidence to show that this court has jurisdiction to impose upon me?
I wouldn't even let him slide that much. I would go right back to the objection, point of clarification, and I'm just asking whether or not jurisdiction is an element of the charge or not. Because if you do that, he's already derailed you from your question, and now you've abandoned that, and now you're lacking a critical confession from the judge.
It's like, no, I didn't ask you for a conclusory statement. I asked you for a yes or no.
Okay. Should I say that, or should I just...
No, being that direct would piss him off, but
yeah.
I'm just pointing it out.
All right, then objection. Is jurisdiction an element of the charges?
Mr. Jamar, I've already told you we have jurisdiction, and just move on. Why do you keep persisting on repeating yourself?
Objection, clarification. You say that you have jurisdiction, but the question I asked is jurisdiction an element of the charges, and you haven't answered. So is jurisdiction an element of the charges?
Yes.
Okay, so since you've stated that I'm presumed innocent of every element, does that extend to the element of jurisdiction?
Yes, of course it does.
Okay, then what evidence has the prosecutor submitted to show that the court would have jurisdiction to oppose on me?
Now, Mr. Jamar, I've been on this bench for 25 years. In all my 25 years, no one has ever dared to challenge this court on such a trivial matter. Now we're not here for you to make all kinds of allegations against this court, thinking you're not subject to it, talking like some sovereign citizen. No, all I need from you today is a plea of guilty, not guilty, or no contest, and then we can just move on. Okay?
Well, objection. A point of clarification. I asked, is that a yes or a no to the question I asked? What evidence has the prosecutor submitted to show that this court would have jurisdiction to impose on me?
Well, I think you're a bit confused because you just asked me yes or no to a question that is not a yes or no question. So maybe you need a little bit of time to consult with an attorney, since obviously you don't have a very good grasp of these proceedings. So what we're going to go ahead and do, we're going to give you a public defender.
Objection.
What? Objection what?
I represent myself. I don't need any representation.
Oh, okay. You're waiving your assistance of counsel. That's just fine. All right. So what you're going to need to do from here on, Mr. Jamar, since you have just waived your assistance of counsel, we're just going to go ahead and schedule you for trial, enter this not guilty plea on your behalf in order to...
Objection, sir?
What?
My intentions are to plead guilty today, but I haven't... or what evidence has the prosecutor submitted to show that the court would have jurisdiction?
Okay, time out.
Okay. All right, I'm a little nervous, but yeah, go ahead.
Okay, time out. I just told you waived your assistance to counsel and you didn't object to a goddamn thing.
Okay.
Yeah, you're not waiving your assistance to counsel. You don't want a public defender, right? For other reasons.
But you're not waiving your right to counsel. Do you know what it means when you waive your right to counsel?
No.
It means that now we get to hold you to the standards of a lawyer.
I could argue against that myself.
Yeah, you could argue against it.
I'm not interested in waiving any rights until after I've been informed. That's the key.
So yeah, and don't go. You're not representing yourself.
Yeah, unless you know what that means. If you know what that means, I'm all ears. I've been trying to figure it out for good 16 years, 17 years. So. We're being brutal, by the way. Keep in mind, we're being brutal. Standard disclaimer: we're being brutal to toughen you up, not because we're mean people.
Yeah. So I mean, you never say that you're representing yourself, okay? Because you don't know what that means. I don't know what that means, right? And also you're not trying to waive any rights. When you say you're representing yourself, they're going to take that as, just like I did, that you're waiving your assistance of counsel. Okay, that's great. Okay, moving on.
Yeah, might come up that you do turn out to want one. You never know.
Yeah.
So would I say I don't need a lawyer for my own defense?
Well, ask him.
No.
Ask a question. It's like, would I need a lawyer to be informed of the cause and nature of these proceedings and plead guilty here today? Is that a requirement? There's all kinds of questions. I'm just coming with one off,
Do I have to get a lawyer to get the prosecutor to state a case? Is there a case?
Yeah. Or you can simply put it off with we can do, I can. Well, I'll figure out the lawyer bit in a second here. I'm just trying to figure out the answer to my question first, which is, you repeat your question. I mean, any topic that isn't cool, you can say, okay, we'll pick that one up right after I get the answer that's on the table.
Okay, now when I object, would it be just objection, and I wouldn't have to say point of clarification? I would just stop the conversation right there. And
just saying objection by itself means nothing but I don't like that, and it's a really, really weak thing to say. I mean, objection can stop a sentence in order to give you a moment to review your notes and so forth. But a lot of judges will knee-jerk reaction, not let you even give the grounds for your objection, but say overruled before you even say
what you're objecting to. But then again, that's a topic for discussion as well. It's like, I'm sorry, are you completely uninterested in the grounds for my objection and want to overrule me no matter what the objection is about? You know? So what I'm objecting to is completely irrelevant to you trying to overrule it. And that itself looks bad too, right?
Judge, what if my objection here was the only way to get at justice? Would you still overrule it?
Yes, I would, because America.
I mean, for all he knows, your objection could be, objection, there's a kidnapper who took my daughter and you know, whatever. You know, he doesn't know. It could be anything.
All right. So, I mean, as far as the whole assistance of counsel thing goes, you know, the easiest way to just wave that away is say, you know, objection. At this time, I'm not seeking a public defender. I just need to be informed so that I can make such determinations. Because without being informed, right, you don't know what kind of lawyer you need.
Well, I mean, you'd know generally.
And they'll,
you know, you know vaguely what kind of a lawyer, but you wouldn't be able to really interview him super well without knowing all the details.
well, we read you the charges. That's all you need to know.
Yeah, most people also choose a lawyer pretty randomly, don't they? They don't interview for nothing. If you were really, really trying to interview a lawyer, you know, and you were a good little statist and so forth, you would get all of the evidence that you could, all the details, so that you could talk to lawyers and discuss all the details and see if they were knowledgeable about such issues. But no, people tend to interview for a damn. You know, if you were put in charge of hiring somebody as the new cashier at McDonald's, you'd probably have more questions than people generally do when hiring a lawyer. Yeah, I guess people don't think about the fact that they should interview their lawyer kind of rigorously, even if they choose that lawyer. You know.
All right. So let's get back into it. Oh, so you're waiving your assistance of counsel. That's great. Well, we can certainly enter that into the record.
Objection, sir. Point of clarification. I did not say I'm waiving my right to, my counsel. I'm just trying to. I basically just trying to find out and become informed of the nature and cause of the proceedings, so I can be better informed, so I can make a plea.
Is there a question mark at the end of that? Come on, man, end on a question.
So, what evidence has the prosecution submitted to show that the court would have jurisdiction to impose upon me?
Well, sir, don't you have that ticket right there in front of you?
Objection. Point of clarification. How is the ticket evidence of jurisdiction?
No. Okay, so that's going to be a good question here in a minute, right? But right now, you know, if the judge points to the ticket and says, you know, don't you have the ticket, right? Then you want to clarify what he's saying. So are you saying that this is the only evidence of jurisdiction that the prosecution has submitted?
Or this contains, or this references, or this.
Yeah. Are you saying this document, you know, describes the only evidence of jurisdiction that the prosecution has submitted?
He didn't say anything. He asked you just incidentally, do you have a copy of the ticket? If you went on a rant about it, he could say, I wasn't saying it was. I was just asking if you got a copy of it. You know, why are you going all off into the bushes over it, right?
I wasn't listening carefully enough.
Right. They're playing word games, right? So be careful of them.
So I mean, my first thing would be, you know, a point of clarification. Are you saying that this document contains, or, you know, describes the only evidence of jurisdiction that the prosecution has submitted? Because that's what he's inferring, right? But you want him to state it clearly. So let's try it again. Well, you got the ticket right there in front of you, don't you?
Objection. Point of clarification. Are you stating that The ticket I have in front of me is the only evidence that the prosecution has submitted to show that the court has jurisdiction to impose upon me.
No, of course we're not.
Okay, then what evidence of jurisdiction has the prosecutor submitted to satisfy their burden of proof?
See, and right there, the judge is in a bit of a bind. So he's either got to point to something else, which, if that's the only thing there to point to, it's like, he's got to deflect, or he's got to go on a rant and threaten you, right? So he's in a corner.
Move the goalpost now to the geographical area.
Yep.
Well, on the ticket, it says you're within the county of bullshit, and the officer will testify to that at trial.
But you notice with that answer that Gabe just gave you, he didn't say that it was or was not.
Okay.
He didn't answer the question. He just misdirected.
Okay. Would I object to that, or would I just...
I certainly would. I would get him to either commit to or abandon the ticket.
Okay.
I'd say objection, point of clarification. I just asked if you're saying that this ticket describes the only evidence of jurisdiction that the prosecution has submitted. It's a simple yes or no.
What if I just said, objection, point of clarification, was that a yes or a no? Would that be too in your... Or...
What was your... It's too easy to forget the question if he's muddying water up a little bit. So, I mean, if you want to say that, is that a yes or no to the question and then restate your question? Restating the question is not a bad thing. I know it's rude and common just conversation, but you're trying to make it clear that you're asking questions and they're just really being elusive. So I like the idea of saying it exactly the same repeatedly when they're not answering it,
Okay, so objection. Point of clarification. What evidence of jurisdiction has the prosecutor submitted to satisfy his burden of proof? Or, sorry, was that a yes or no?
It's not really. That's not a really yes or no question. Okay. But I realize that you're reading it and it wasn't given as a yes or no, probably.
Okay.
I like baby steps. I like asking if he's submitted any at all. Has the prosecutor submitted any evidence of jurisdiction? Makes a yes or no. He kind of combined it up into what evidence, which is still the same sentiment, the same thinking,
The question you should have been re-asking is, since I had identified the ticket earlier, you could go all the way back to that one, fine, but I like to go back to the ticket because I want him to say yes or no on the ticket, so we can either keep going with the ticket, or we can just ignore the ticket entirely, because it doesn't matter.
Okay.
So if he says yes, okay, we'll keep going with the ticket. If he says no to the ticket, then, the ticket was irrelevant to your question.
Okay, so if he keeps going with the ticket, then are we just breaking it down then? Like just trying to figure out what part of the ticket?
Yeah,
okay.
Yeah, but we first need to get him to commit to the ticket.
Okay.
Because if he doesn't commit to the ticket, there's no point in tearing apart the ticket. Because all he's going to do is he's going to point to something else, and then point to something else, and then point to something else, right? You want him to commit to anything. Then you can tear that thing apart.
What if he said it? What if he said it's not the only thing? Well, the judge said it's not the only thing. It's like, okay, so it is one thing, right?
Yeah.
Well, then we can attack it still.
Yeah, then we can attack it still. Right?
Yeah.
And then after we've finished attacking it, saying, okay, well, we've already dispelled the notion that was one of the things you said it was. What are the other things?
Mm-hmm. Tasty little crackers. They just crumble. So, let's see. So, where are we at? You were at objection, point of clarification. Maybe I didn't ask my question loudly enough so you could hear it clearly. But the question I was asking was a simple yes or no. Is this the only thing that the prosecutor has submitted to establish that this court has jurisdiction to impose upon me?
So right there, it's, clear exactly what's going on, right? That you either didn't hear his question or ignored his question or something, right? And so he's asking it in very clear terms, hey, what's the answer to this?
Mm-hmm. Yeah,
it's nice and confined. It doesn't presume anything outside of what's already occurred in court. You're not asking about the universe. You're asking about something that occurred in his purview, right? So he should be able to answer. He should, he doesn't have an excuse of I don't know. If he said I don't know, the question becomes, okay, so is this court completely unaware of where this court stands as far as evidence? Or you simply drive that wedge where it's like, okay, do you mean you don't know as in the court itself doesn't know, or you don't know you personally don't know?
That too.
Because he'll constantly refer to himself as the court and judge and whatever interchangeably. So like, okay, so you and the court are completely different on, you don't know it, but the court does or should,
So is this dance just between like myself and the judge, or like at what point
yes,
would be...
but the entire point of this dance is to eventually get to the point where you can drive a wedge between the judge and the prosecutor, right? Because we keep mentioning the prosecutor submitting, right? The prosecutor doing this, the prosecutor doing that. And we're hoping at some point they'll pick up on it and be like, hey, I can pawn this off on the prosecutor.
Right.
Mm-hmm.
But the idea of bringing that judge, because that judge starts out kind of like on that prosecutor's side of the table big time. Right, where with the number one, your intention to plead guilty, you're facing that. You're looking at him across the table, so to speak. And then with as you get to number two, if you do, the gun in the room issue, he's a little bit more, hopefully being brought around to your side of the table a little bit, and you're just saying, hey, I'm just here to deal with threats of violence, yada yada yada. And then in a latter phase, you're starting to talk more and more about the prosecutor's failure, or that you're hoping the judge is seeing and picking up a little bit more in that prosecutor's failure. And the hopes are that he'll eventually say, yeah, Mr. Prosecutor, what evidence have you submitted? Because that's a big field goal right there. And oddly enough, it's happened recently. It used to be thought of as unthinkable, but we've actually have now recordings of people doing it.
Last week, he goes up and he asks the judge, what evidence of jurisdiction has the prosecutor submitted? And the judge looks at the prosecutor and says, state? And the prosecutor just sits there dumbfounded for a minute straight. And then says they'll be dropping that case.
Nice.
Yeah, he asked 2 questions and got a 10-year felony charge kicked out.
Awesome.
These results are not typical.
Yeah.
By the way.